Madam, I am in the virtual mode.
On behalf of the audience. So you have joined? Yes.
Namaskar.
So why instead of filing review application, you could have filed, you can challenge that order before higher forum.
Sir, actually, my fundamental right has been hampered. That's why I was requested for the writ petition and writ under the 226 article. But the order is that CPC is not. It's not suit. I have not applied for the civil suit. So non-gender is not applicable to the 226. So it's the it entirely is Honorable High Court will decide that my fundamental right is hampered.
Right. So according to you, the doctrine of non-joinder of necessary party will not apply in writ proceeding.
Yes.
Because CPC is not applicable
Under the
in writ proceeding. So you are mistaken, madam. You are mistaken. Principles of CPC do apply, though the provisions of CPC don't apply in writ proceedings. The principles of CPC don't do apply.
Do apply.
Therefore, instead of you may call it wasting your time before this court, you should have approached higher forum. And the whole difficulty is that
there is the opportunity I can request because as I said that my financial condition is not so good, so that's why I cannot approach in the upper court. So
financial condition is not an issue. Financial condition is not an issue these days because if you want, the Supreme Court Legal Service Authority can provide you legal aid.
But if I get the justice here, then there is no point to
justice.
ask.
You cannot get justice because so many reasons.
Sir, I am a sports person. It comes under the special provision.
That will not change the law, madam.
The law is there to protect the interest of the citizen. I am the ordinary citizen of this.
We might have committed wrong. Our judgment may not be correct, but we are not there to say that this judgment is incorrect.
I am not the person to judge the Honorable High Court, but I can request for my because I am in the problem for 2.5 years.
Sorry, madam.
Sir, this case CPC is applicable in the date when the person is not hampered, when the person interest is not hampered. Here, I am the victim. So my person.
You have the conception. We don't know right or wrong. That you know better law than all the lawyers and all the judges.
So law is there to
convince
the interest of the citizen. I am the ordinary citizen.
All right, we will not enter into further argument. Dismissed.
Thank you. No list.
We're taking the liberty to make a common mention of the same item. Today it's at item 53. Of course, there are other councils also. So we've had a common consensus that if it can come on 7th at 2 p.m. The
What is this matter about?
Your Lordship, it's a matter where a tender has been challenged. Plus, there is a PIL also challenging the same tender. So there are two connected matters there. And there's a stay operating.
Have you taken consent of the other?
We've informed other parties. The OCAC is here also. We've informed the petitioner. And Mr. Ashok Parija is also appearing in the matter. We've informed him also. So all of us are agreeing.
So OCAC, Ms. Manti is there.
Yes. So
and why 7th? It's a lucky day or what? Why 7th particularly?
No, Lordships, we do know that there are matters fixed. Somehow we know 7th we can get a date.
All right, 7th.
2 p.m. Lordships.
Give the list of cases.
Lordships.
All the cases are on
all there. Item 53, both the matters are there.
You have to inform the other council.
Lordships.
Item
53.
Jain, my lord.
Pardon to mention, my lord. It's out of list, my lord. It's the urgency is that interim order is operating. I am the successful bidder, my lord. I have deposited the entire security deposited and.
Have you filed any application?
Yes, my lord. I have filed an application for vacation of interim order.
Have you served a copy?
Yes, my lord. Since long.
When did you file?
My lord, in the month of February 2024.
So whether the notice was issued, you were heard at the time of.
No, my lord.
Passing of the order.
No, my lord.
Then by virtue of 226(3) that
Your Lordship, that is there, but automatically they are not allowing us to issue
Tell
work
them,
order.
if they don't allow, then you will consider your. You tell them. Give this
I have already stated before the authority because
question of stated.
no,
You
they are
can
not.
tell them that this is the order which was passed. This was passed behind your back. You file an application on such and such date. Serve the copy and then.
What is the problem? Interim order is extended time to time. The case was listed. Thereafter, it has not been taken up, but the interim order has been extended from time to time.
After your appearance.
Yes, my lord. That is the problem.
All right, then inform the other side, we will take up.
Yes, my lord. I will inform also.
Have you taken consent?
No, my lord. I will inform him.
Inform him, then make a mention.
Miss Roth is appearing.
Ms. Rath is not here.
I will inform him.
Inform him, then make a mention.
Yes.
My lord, contempt matter, division bench matter, my lord, can be taken up. Contempt matter, my lord. Division bench matter can be taken up. This
Contempt matter is not urgent.
The benefit,
Thousands of contempt matters.
my lord, benefit of the petitioner not
Huh?
granted till date. The benefit of the petition not granted till date.
Oh, which
The
benefit?
labor matter, my lord.
Which matter? Which benefit?
Contempt matter, my lord.
Which benefit has not been granted?
This single, the division bench matter, the bench already abolished, my lord. Prior division bench.
Your client is entitled to certain benefit.
My lord.
Which benefit? What is that benefit?
They are laborer, they are appointed, they are continuing national annual matter. Till date, they are
Give
not
your slip,
engaged.
I'll see.
I may be pardoned, my lords. I may be pardoned, my lords. These are a batch of criminal revisions, my lords. These are a batch of criminal revisions which are specifically assigned to your lordship's division, my lords. The matter pertains to, my lords, release of vehicles under the NDPS Act.
That will be taken up. On 2 p.m. it is so.
Intimated.
Give your slip.
Only one and she has some difficulty.
What is it today in the list?
No, it is
Out of list.
Jain, my lord. Jain, my lord.
Yeah.
My lord, I am Lieutenant Colonel Mukul Chauhan. With your permission, I want to make a small mention regarding our pending civil writ petition 16599 of 2018, Major KD Singh versus Union of India. It's a long pending matter, my lord. It requires an urgent hearing, and I have already filed a mention memo in this regard. I made a mention before a single bench also, but they asked me to make a mention before the Chief Justice's bench. Could I request, sir, if that could be permitted?
No, send your slip, I'll see. Send your
Sorry,
slip.
sir?
I'll see. Please
I
send your
shall.
mention slip, I'll see.
I will send it across. It will be sent to the court. Thank you so much. Jain, my lord.
In this case, my lord, the petition has challenged the cancellation of tender and government has decided to go for a fresh tender, my lord. I have obtained instruction, my lord, enclosed in the proceeding, my lord, wherein the government has decided for the fresh tender, my lord. I have enclosed the proceeding of the government, my lord, at next page 40, my lord. And the last page, my lord, government has the committee of the tender committee presided by the secretary, my lord. They have decided to cancel the tender and go for the fresh tender, my lord. And if your lordship will say, then I'll counteract it.
Well, here, if your lordship remembers, I don't have a right, legal right, if it is cancelled. But law is well settled. Even that 2G spectrum case also they have held. And Tata Solar also, paragraph 85, it hasn't held. And the recent decision I cited the other day, if your lordship, they must assign good reason. It is in public interest. But they have to show that, yes, a fresh tender is imminent in this instant case. When my name has been recommended by the tender committee, after I became the L1 and I have become satisfied with all the criteria. So no reason has been assigned. If your lordship looks at the instruction also, no reason has been assigned. Let them file counter, there is no difficulty, my lord. But
Mine.
2 weeks,
Mine.
2 weeks time allowed for the state to file a counter.
Obliged.
the same liberty may continue well that the event they float, I'll file an interim application. They have not done anything till now.
No, why, that liberty is there or
Yes,
that liberty, that goes without saying, even if that is
Yes,
not
yes.
recorded, you can make,
if they do it, I'll
do it.
Mine.
Item number 2.
True also, your lordship, it pertains
same.
same.
But here the retender has been invited not to finalize because if the excess rate will be without any reason, they have once the bidder no price bid is open and
Price bid has been opened.
and so it was recommended for government when this matter going to government that some of the bidders will not be keeping on eye, they have cancelled. Similar for the instant to give
Bidders cancelled.
tender cancelled. We have challenged. Now the retender has been invited, my lord.
Lordship, I
Retender
give
also-
2 weeks time, your lordship, I'll file a detailed counter affidavit.
No, final decision shall be subsequent tender, which is improved.
So we can say that any decision shall be subject to final
Yes, sir.
adjudication.
Yes.
Right.
3 is also the same, your lordship.
Yes, sir.
Any adjudicate, any decision, final decision based on the tender floated on.
The subsequent.
Listen to just 1 second, Lord.
So 24/6.
24 June.
No, madam.
Right.
29 February 2024, second tender.
Second tender.
Yes.
In line
February 2024.
shall be subject to final adjudication. But why have you come? Why
Well, there is a election. They did not, because of my writ objection, I objected. They made a corrigendum. The tender was dropped. 22nd, it was not acted upon. By 2nd July 2024, my lord, they made a corrigendum to again reopen the tender. For that reason, I come. The original, that reason I come, my lord.
Because
There
of
is
election,
post the elect
code of conduct.
code of conduct. Thereafter, corrigendum was issued, my lord, to open the said tender, my lord.
not
And third one,
same?
your lordship, sir, only date, tender date. My lord, the third one is 23rd February 2024, date of tender.
Date.
That's all.
Adjourn, huh?
Item number 4.
Item 4, I may kindly, and on behalf of Ms. Mahapatra, my lord, 1 week time may be kindly permitted, my lord. She is not well.
Yes. My lord, I am appearing for the respondent number 3 and 4. Last occasion also time was given. And on previously he has filed a 1 writ petition and the order was to approach the executive tribunal. Instead of approaching, now again he has approached another writ petition and that was also directed to approach the appropriate forum under section 10A.
Tomorrow? Tomorrow.
Item number 5.
My lord, the delay has been condoned. Matter relating to that Narsu Pradhan matter where regularization of entire work charge period. The Lordship have posted similar matter to 22nd 8.
22nd August.
22nd date. Along with. So have you prepared your the judgment citation?
Yes, judgments I have come prepared, my lord. That is the latest judgment of 2023.
Use those.
That is Uday Pratap Thakur and State of Bihar.
Before that matter is taken up,
My lord.
please give the citations and
Right.
what has been decided.
Right.
Gist of that.
Item number 6.
Number 6, may I please, Your Lordship? My Lord, I am appearing on behalf of Mr. S.N. Patnaik for Staff Selection Commission, who is the appellant in this case. My Lord, here, the appellant is challenging the order dated 12/1/2024, my Lord.
Yes.
My Lord, here, my Lord, may kindly see page number 21, the order of the...
Yes.
The submissions, my Lord, that is very vital, I'll place it. Para 4.1. Lord, Learned Counsel for the petitioner contend that in the online application so submitted under Annexure 2, petitioner clearly indicate that she belongs to PWD Women Category 3, but while uploading the certificate, though she indicated the certificate number as well as the date of issue of the certificate, so issued in her favor under Annexure 2 series, but wrongly uploaded the HSC pass certificate, which was also uploaded showing her qualification to have 10th board from Board of Secondary Education. But here the main contention is that the advertisement clearly prescribed that the certificates need to be uploaded while filing the online application. Here, this is not in dispute. There, the opposite parties are agreeing that the certificate was not uploaded. But the Honorable Single Judge Bench has observed that the matter is trivial in nature, hence she may be given appointment. Madam, may kindly see Para 7.1.
That's the only point.
That is the only point.
It's for the other side.
I don't know. It's a fresh admission matter. Appeared, no. My Lord, I am appearing on behalf of Mr. S.N. Patnaik, appellant, my Lord.
So your name, please.
Nihal Rath.
All right. In case you accept her application, how does it prejudice the selection process or because one more participant will be there in the field? She possesses the qualification. On account of a mistake, she has not uploaded. But because she has given the details of the certificate, that means that she was in possession of the certificate.
My Lord, the details. My Lord, here the advertisement. Here, the main
Understood.
The
Advertisement required that you should upload your copies of those certificates.
Because before the document verification part, the commission is nowhere entitled to see the documents, whether she was having those documents or not. My Lord, when the advertisement prescribes the conditions in which...
Just sorry for interrupting. If you say that the commission at the time of application is not supposed to scan the documents, then did she not produce it subsequently?
My Lord, she had not uploaded it.
That we have understood.
My Lord, may kindly see the application where she had written also the HSC certificate in place of that. My Lord,
so that obviously is a mistake.
That's a mistake, my Lord. And in that point of time, she was considered in your category and she secured marks lesser than the last selected candidate in your category, my lord. But here the main question that arises is
because she had not uploaded her certificate, you considered her in your category.
And that was the main problem, where advertisement clearly prescribed if any wrong, she had to be vigilant when at the time of
Understood, but mistakes happen.
My lord, if that
Whether that is that so serious that we have to consider.
My lord. And if that is permitted, my lord, many applicants will come up with that question whether they also may have made some mistakes with respect to the application form. And if that is allowed in the later stage or later point of time, because advertisement clauses are admitted while filing the application.
No, she's not the only one.
Consequence mentioned?
Pardon, ma'am?
What was the consequence mentioned in the advertisement?
My
if
lord,
the documents are not uploaded.
My lord, it can be cancelled at any point of time, my lord. My lord, I may be permitted to read, my lord. If at any stage of recruitment or thereafter, it is found that any information furnished by the candidate in her or his online application form is false, incorrect, or the candidate has suppressed any relevant information, or the candidate otherwise does not satisfy the eligibility criteria prescribed for the post, her or his candidature for the post shall be cancelled. She may further be debarred either temporarily or permanently for the recruitment examination conducted by the commission.
That will not apply. The question is, what is the consequence, or what was the consequence prescribed in the advertisement if a particular document was not uploaded?
My lord, the clause says that she would be debarred if any fault in the.
If there is any suppression.
No, my
lord. There is any wrong information given.
My lord, it's written or suppression, my lord. My lord, there are three stages that has been divided in the application clause.
What?
My lord, I may be another, my lord, 2C, my lord. Okay. PWD candidate must ensure that they possess permanent disability certificate of the above category as per clause 2B and must upload the scanned copy of the original disability certificate issued online, not photocopy, card by the competent authority.
If it must is not done, then what is the consequence? Must, it's mandatory.
My lord.
It's clear. There are two aspects.
My lord. My lord, the first aspect that
you say that on the date of application, he did not have that certificate. The matter is different. He subsequently obtained, and therefore, second circumstance is that she had the certificate, she gave the details, but she did not upload as was required in the advertisement. This is the change. Her candidature, as per the advertisement, as PWD candidate, was not to be considered. Agree? You are not required to, you could have rejected. But now, since single judge has shown indulgence, and it is not going to prejudice the process of selection. If you demonstrate that because of this, it will affect the entire selection process, the matter is different. Okay. But if you are getting one more candidate, that too PWD, PW physically challenged, then why should we interfere in such matter?
My lord, here the main question, if my lord may permit me.
No, another thing. This is a beneficial legislation or whatever to show them preference. So if we are very strict, that benefit will be denied to the candidate.
My lord,
but as a question,
we will hear you tomorrow. You seek instructions from OPSC or what?
Yes, ma'am.
Staff selection.
Staff selection.
Staff selection as to how, if because of this order, there will be some problem because everything is being done online. So if that will disturb, then we may consider. Otherwise, these petty matters, this court should not. We will pick up tomorrow and just seek it.
My lord, just another day, my lord, just one day.
One day, only? Thursday?
Thursday, man.
List this matter on Thursday so as to enable learned counsel for the appellant to seek instructions from the Staff Selection Commission as to whether treating the respondent as PWD bracketed W candidate, comma, in the light of the order passed by the learned single judge shall have major effect on the process of selection.
That's good.
It's a simple thing. And you can convey also that
My lords.
minor. The
That-
others may come with the same grievance, we don't know, but
Well, that is the only difficulty. If other application at this point of time is entertained with a defective application, then it would create.
no, when was the order passed?
And there was an interim order passed when
Well,
the
on 2000
appointment was not given. One post was
One post was kept.
kept vacant in the interim order.
Who's accept you?
Yes, sir.
Oh, one post has been
Yes,
kept
yes, that has
vacant.
been reflected in the final order also.
Then no difficulty.
So there will be no prejudice. That has been the
Well, I'll seek
conclusion of the honorable
Yes,
single
yes.
Seek
judge.
instruction
Yes.
after that.
I am
what-
another candidate. I have already been selected by virtue of a court order and I will continue. Now the allegation is against me, but the learned single judge has not given me any opportunity. No notice was issued to me. But the honorable same bench has allowed the case of the present respondent, my lord, for whom I am representing here.
Where is that case?
That has been allowed by the honorable single judge and I have been given appointment.
So where is that order?
Or my case is
You're saying you were not heard by the learned single
in
judge?
this particular case, my lord, in the writ petition, I was a party as I have been received from this notice. But in the writ petition, no notice was given to me. But I have filed a case independently when my candidature with regard to my disability was rejected. This honorable court directed for adjudication of my disability by the appellate medical board. Appellate medical board, I was rejected only because my disability has been reduced from
No,
45.
whether you are party in the present appeal or not.
In appeal, I have been made parties. In the writ petition, though I was a party, no notice was given to me.
All right, in the appeal, you are a party.
Yes.
Are you objecting?
No, if my appointment is not, now I have been given appointment by virtue of an order of this honorable court. If that will not alter, I have no choice.
Order of this court in another case.
My case.
Yes, so that was another application.
Yes.
But-
Independent application.
But
Yes.
fact remains, interim order was that one post was kept
That
vacant
we have understood.
prior to
Yes,
appointment.
I have been
One post
appointed.
is vacant.
Pardon?
Yes.
One
As
post
per the interim order, one post
In
was
this
back.
particular case, but I have not, I have been appointed in the.
So what is that writ application where you, pursuant to which you have been given? So first day order or after notice?
No, it is a
All right, all right, give us the. Okay.
WPC 4171 of 24.
Oh, this was what.
Item number 7.
In item number 7, my lord,
May please, my lord.
I've been added as a respondent. And no, I'm in caveat, my lord, they have not served me copy as yet.
Just now, I'm sorry. In this case, the appellant has challenged the order dated 24/6/2024 passed by the learned honorable single judge in WPC number 11,208 of
Your
2000.
lordship may call it some other day because I have to go through. He has not, I'm in caveat, he knows very well, but he did not serve me copy yesterday also.
No, but you may not be required to.
As your lordship, please. As your lordship.
Why are you wearing the mask, Mr.?
My lord, I am suffering from fever and cold. I should not get others infected.
Then wear it.
By that, I cannot address properly.
No, we can hear you.
I should not infect others.
The fact of the case is like that, my lord. On 7/8/2021, one advertisement was made for appointment of PDS distributor in the district of
Copy of the writ appeal for.
May I pray, my lord, for interim direction? Pray for interim.
In this 1 week, will anything happen?
He has already been removed from 1/7. I've got the order. He must not be knowing that. He has been removed from 1/7 and we are today on 30th.
Yes.
Item number 8. All right.
Grateful.
Item 8. I think the counsel who was appearing earlier, he has withdrawn his power. And nobody is appearing either in person or through any counsel. And the purpose for which it was filed now, so it doesn't survive anymore. The allegation is that sometime in February 2024, a scheme was floated by the state government, which is not consonant with law, but giving some benefits to others, the PDS card holders, 1,000 rupees each. Now that is why if you also look at also the prayer.
There is no representation on behalf of the petitioner. It appears that the petitioner has lost interest in the present case, which stands dismissed for default.
Item number 9. In item number 9, the lordships are pleased to direct me to obtain instruction in this way because it relates to some development work of Noaigad. I have received a letter from the collector. He will be giving the details of some time, 2 weeks time, loss may grant me. It's a public inter-litigation with regard to developmental works of the...
There is no communication, no light, no water, no facility has been provided. My lord directed on 14th of May that at least the grievance of the petitioners may be redressed. My lord, no action has been taken. At least if during rainy season, the water facilities would be provided. They let them file the counter, but at least water facilities would be provided.
Means rainy season, you're getting natural water, you want more water?
Water means they are drinking the water from river.
Okay.
That is, at least that should be provided them.
It's a serious matter.
Yes, that is why also wanted me to give the details what steps have been taken by the district administration for redressal of the grievances.
No, in the meanwhile, you are supposed to address those grievances also. See the order.
Yes, so the collector has not requested to make a prayer before lordships. He will be giving all the details within 2 weeks. That's why
we are adjourning the matter for tomorrow.
Yes.
Ask her to join.
Yes.
The collector.
Yes, please. Definitely.
All right. Discuss matter tomorrow. Stop in view of the nature of the issues raised in the present rate application in the nature of public interest litigation. Discuss matter tomorrow when the collector Ganja Noaigad shall be required to join the proceedings online at 2 p.m. You are a political party.
Yes, madam. Yes, madam.
No. Item number 10.
Yesterday, my lord has directed me to serve the copy up to Mr. Satpathy, Tushar Kumar Satpathy. I have already served on.
What is your grievance?
Grievance, my lord, to provide the password ID to upload the documents for affiliation for the year 2024-25.
You have, have been granted recognition by AICT.
We have already obtained the password and ID from the AICT and also obtained the approval till 2023-24. And so far, BPT is concerned, my lord, they have affiliated till 23-24. I have deposited the amount under Annexure 9 to obtain the same. Still, though they have accepted the amount,
under Annexure 10, and they have not provided the password ID to upload my data, the institution data for get the power affiliation. I have also ventilated under Annexure 2.
Further affiliation.
Yes, 25, 24, 25.
Where is your approval by AICTE for 24, 25?
I have not annexed, but I have already obtained the password ID for the AICT upload.
No. What do you mean obtained password ID for upload? Does that mean that you've got affiliation?
No. Regarding AICT, my lord, it is awaited.
Awaited?
Awaited.
Yes.
But so far BPUT is concerned, unless the password is provided to me for the user ID, I am unable to upload.
Okay.
They have taken the amount for the affiliation, that's 70,000 for the year 24-25, and they have to provide the password. Unless it is provided, I am unable to get the affiliation. VCB is unable to participate in the OJE entrance counselings.
Sir, council
That
law
is
is that you should have approval of the AICTE, whereafter affiliation shall be granted.
Yes.
You were granted approval by AICTE for the academic session 23-24.
Milord.
So unless you get further approval for the subsequent session 2023-2024, 24-25, you cannot get affiliation from the university. All right.
Milord.
Once you are granted approval, the university is under obligation to grant affiliation.
Yes.
But where is that? Unless you have the AICTE approval for the subsequent academic session, how can you get that?
Lord, your lordship may adjourn to Monday. I will take the instruction because they have already got that password ID. In the
Password
meantime,
ID are secondary things. The fundamental things are approval by the AICTE and affiliation by the university.
my lord. So far, AICT is concerned, my lord, they have already provided. I will.
Again, you are saying password ID.
If they provided, you should log in and obtain.
All right. All right. You want affiliation for the academic session 2024-25. You want this?
Yes.
So this affiliation can be granted only if you have AICTE approval for 24-25. Where is that?
But I have not annexed that. I will
Not annexed, then you don't have any case.
I will provide the same. By an additional affidavit, I will provide the same.
Already you have, you bring this, the petitioner, the technical institute within the meaning of the provisions of AICTE Act. Full form. It was granted approval, recognition by the AICTE for the academic session 2023-24, and affiliation was also granted by the university for the said session. So it appears that the petitioner has grievance against the university not granting password and ID, treating the institute as an affiliated institute to the said university. Stop. Learned counsel for the petitioner has, however, not been able to satisfy this court that the AICTE has granted recognition for 2000 for the academic session 2024-25. Stop. Learned counsel for the petitioner seeks adjournment to satisfy this court on the said point. So stop. Set this matter on Thursday. Retaining its position.
We're keeping it to Thursday to help you.
Madam?
You wanted 1 week time because thinking you may have urgency, we're keeping it to Thursday.
Yes.
Item number 11. Lordships, item 11 and 12, I am appearing virtually, my lords.
Yes.
Yes, my lords. Item 11 and 12 appearing, I am appearing virtually, my lords. My lords, this is a GST matter where we have challenged the extension notifications under section 168A. Lordships will remember
Those
similar.
matters are coming when? When are those matters coming?
Yeah, I did.
My lords,
I've supplied the copy, my lord, the last order sheet and the bonds matter, second one.
my lords, it was last listed on 9th of July. The similar matters, my lords.
But why 9th of July the matter was not taken up?
Could not reach, my lord.
Huh?
Could not reach.
It could not reach.
Yes.
So how many cases are there?
Bunch of matters, my lord.
Is this matter on? When? When should we adjourn?
Let them file the counter, my lord.
13th August?
Pleadings has not been completed. Yes, ma'am, 13 August.
13th August?
Yes, ma'am.
Along with all
matter.
along with WPC number 1324 of 2024 and other analogous matters to be taken up at 2 p.m.
Readings not completed, my lord.
Your paper is restricted.
The batch, that is why it has been written in the batch. Because on top there is one number, below
Tata
the-
project.
Extra copy we kindly given.
Yes, ma'am.
Extra copy.
Yes, ma'am.
What extra copy?
2, 3, 4. 2, 3, and 4. 4 is a new party.
Who is for?
2, 3, 4.
Who is for?
4 is Principal Director of Audit, Central Having Habits Office, Bhubaneswar, Keshrinagar, Bhubaneswar. It is a new party in this
I'll
case.
provide the soft copy, my lord.
Right, so
Yes, ma'am.
And Mr. Naik,
Yes, ma'am.
another case,
Tata project is the main case, my lord.
14004 of 2024 by Vedanta. Was it listed on 9th?
Yes, ma'am.
It was listed.
Yes, ma'am. And the main case was the Tata project case, ma'am.
All right.
there was a question in one of the cases about whether the royalty there can be tax on royalty or not.
Your Lordship. That is a group. That is a separate group, Your Lordship.
That is a separate group, and that issue has been decided by Supreme Court finally.
Your Lordship.
So those matters can be listed, and
Your Lordship, I'll give the list, Your
please
Lordship.
give the list.
Your Lordship.
All right, we'll take up those matters and Supreme Court decision also.
Your Lordship. I'll by tomorrow.
My lords,
Yes.
may I just point out in that batch, the question whether in the royalty batch, my lords, whether the judgment will apply prospectively or retrospectively, that has been left open and is still to be heard by the Honorable Supreme Court.
That we will see.
My lords.
For the present, we will see what is the effect of that judgment on the pending cases and the nature of treaty which has been sought.
My lords.
Now, also in these bills, with great respect, Your Lordship, with these bills 168A, Your Lordship, already 2 to 3 Honorable High Courts have already decided the issue, Your Lordship.
Therefore, we have fixed a time.
Your Lordship.
We should take up, and please, we are feel very sorry that a date was fixed on 9/7 and it could not be taken. So it should be decided as soon as it is possible.
Grateful, Your Lordship.
Item 10 and 11.
11 and 12.
11 and 12, my lord.
11 and 12.
11 and 12.
11 and 12.
Tag means notice and thereafter. So 13 now ended.
13th August.
Item number 13.
I'm deeply grateful, my lords.
This is regarding rejection of NOC for the nursing college, which your lordships have fixed up at 2 p.m. At item number 54. This can be taken up along with that so that it will be.
What is the point involved?
He has given me a copy just now.
What is the point involved? Right, we'll take up this matter. What is
You
the
can
point?
go through before 2 p.m. You can go through.
What is the point involved?
Yeah, my lord, the issue is in this present petition that the deficiencies which were pointed out were sent in a non-registered email for which there was a delay in compliance. So on that ground, they have rejected, stating that it has not been complied at the relevant during the appropriate time. Because the registered mail ID is something else, and they have sent it to a second mail ID. So we got the information later on and we sent the compliances, but before the date of consideration, still also they have rejected, stating that it has not been complied.
My lord, we have given a date, within 14 days, the email provided by them, they have to give the information, deficiencies. Here, what he submits, I don't know the file, that he has sent in another mail, and that mail could not be received by us. But the mail which was provided to
That's
us.
the other way around.
No, my lord. We have applied through it because there was a glitch.
No, in short, they have sent to an unregistered mail or you have sent from an unregistered mail?
The compliances have been sent by the registered. But the earlier one, my lord, what happened when we applied for the NOC, there was a glitch in the DMET. This thing, it was not receiving from the registered mails of any of the colleges. So there was a second mail which was created for uploading the entire, and that has been done by many of the colleges. I have given the list also. So they have sent it instead of the registered mail to the other mail. So that is why the delay happened, but it was well before the consideration date fixed by your lordships in the earlier case also otherwise. But definitely after the 14 days time that was fixed by them. So, and there has been NOC from the earlier years also. So the students are also there who have been in second year, third year. So this NOC will also hamper the entire.
Take up at 2 p.m.
Yes, my lord.
In the meanwhile, you can seek instructions.
Yes.
It is the PIL award.
But wait, please, Your Lordship.
PIL.
But this tender matter.
Paperless. Okay. All right.
Yes. But the tender was floated for housekeeping. A district headquarter health centers. But here I'll just indicate that there are technical bid and financial bid. Technical bid contains two parts. One, eligibility criteria. If I satisfy the eligibility criteria, my case will be considered for technical bid. And technical bid, while considering, they should award marks. But you kindly mark this important part. They will award marks on the basis of the technical evaluation. Those marks are eventually at the time of after opening of financial bid, if two persons are equal, then the marks awarded in the technical bid will given the weightage. That is how they have tried to evaluate. But in this case, I have satisfied the basic eligibility criteria. Whatever documents they require, I have given. They have given two ISOs to be given, that International Standardization Organization. So those things I have complied with. What they did, they have issued a notification saying that your standard standardization certificates appears to be defective, invalid. And you are called upon to answer why it is invalid. Why appear on the day they fixed. So after I appear, I produce all the documents, including the website where the standardization certificate was obtained. And I connected them to show that at the time before I made an application, while I made the application, until today, the certificate is valid. It's not invalid. Interestingly, on the very same day, they considered my application and everything that they wanted. They finalized the technical bid and they evaluated the financial bid also. So my grievance is that I have complied everything. I cannot be deprived for the purpose of considering my technical bid and evaluation of the same, and consequentially the financial bid. If your lordship kindly turn to.
So the work has been awarded.
Sir?
The work has been awarded to someone.
No, it has not been awarded. Page 65, if your lordship looks at it. I'll just bring your lordship the basic things.
No, but was the notice to the effect that you should explain as to how the certificate is not invalid?
I have explained.
So peculiar notice, if this is the notice, that you tell us how is this not illegal? How is this legal? That can have some
I
explanation.
furnished those compliances. I have given those certificates. They say it is invalid. But the authority who granted the same says it is valid. Till today it is valid. And I have a long experience in the same. Housekeeping.
So let them file affidavit.
Right.
Is there any private party?
But yes, but it's there. Those who have been shortlisted, in fact. Interestingly, those persons, no, I'm sorry, I'm not included in this party. I'm sorry. Because it has not been finalized.
4 weeks time is allowed to file counter.
But the Liberty, if they want to finalize, then they should move an application for interim.
That liberty is also there.
It should be indicated subject
to be stated in the order. If they finalize, you can file an application.
But short time so that it can be disposed of on the next date. Because that's the only point.
Can be disposed of.
That like that Rosemata matter, actually, your lordship knows, your lordship give a detailed judgment. I think it can be disposed of on the next date if you'll get the instruction.
And Mr. Mahanti, please check if that Care Security and Allied Services has filed one case, because the name seems very familiar.
Only two
This week or last week we have.
Right. Item number 15.
In item number 15, I've received the information, so now we have sanctioned the amount and it shall be paid in due course of the week. So let's call it on Monday. In the meantime, I will file that affidavit. This is the instruction I'm giving to my friend. Instruction from the state government to the chief engineer to make payment within this week only.
As your lordship.
As requested on behalf of the opposite contenders, list this matter on Monday.
For orders item 16.
It's a dispose of matter, matrimonial application. I have filed an IA for clarification of the order. Lordship may kindly have a glance on the order.
IA for clarification.
Mine.
Which order?
25/7/2023. Regarding the permanent alimony
Just
paid to the wife.
Just
I'm for the appellant, but copy not sought. IA copy has not been sought.
Where is the order?
25/7/2023. That is the order I seek for clarification.
Calendar order.
So you are seeking clarification because of the language issue or?
No, my lord, there is needs to be modified also because direct direction was given to pay 80 lakhs to the wife as a full and final permanent aliquot.
Order dated?
25/7/2023. Though I have complied, but a contempt proceeding has been initiated against me. 25th April 2023.
Passed in this smart MATA 38. Are you sure about your date of order?
Yes, I am having the order with me. Lordship may kindly
Give us.
25/4.
25/4.
25/4.
And,
But Council, you are repeatedly saying 25/7.
and where were you yesterday?
Yesterday I was in another court. I rushed.
So that we are supposed to know without anybody informing us.
I came up when the matter has already been called up.
You are repeatedly saying this.
25th
And
4
we are able to
2023. I'm
find
sorry.
out.
25th 4 2023. I'm sorry. So here what happened in this case, my lord. There is
Just
a
a minute, what is the clarification?
My lord,
Let us see the direction.
Lordship may kindly have on paragraph 11 of the order. May I read?
So you are?
I am for the husband.
So what have you done?
Yes,
80 lakhs has been paid to her?
80 lakhs I am supposed to pay. 80 lakhs.
You had deposited in the High Court.
At the time of admission of matter, I have deposited 30 lakhs as a precondition for admission.
All right.
That was deposited in the name of the registrar judicial.
So that amount has been paid.
No, she has taken that amount.
All right. She has taken the amount because of the order of this court.
Yes, sir.
And 50 lakhs further were required to be paid.
I have paid 48 lakhs because the interest accrued out of their 30 lakhs has been taken by him. Her.
Interest accrued on?
Out of their 30 lakhs. It was deposited. So it accrued some interest.
Or not?
80 lakhs I have paid.
All right.
With that interest. So my only paid.
We are not satisfied with what you are submitting.
Madam.
That 2 lakh interest earned on that
Madam.
should be deducted from the.
That is my only prayer.
There is no clarification required.
Because it was settled with 80 lakhs. That is the language.
Contempt proceeding pending.
Yes. They filed a contempt for 2 lakhs.
Where is that contempt pending?
That is pending here in this court.
What is the number?
Number is filed, contempt number 3196 of 2024.
We have been informed that the contempt petition has been filed by the respondent.
Yes, present matrimonial appellant.
Appellant.
By appellant?
Appellant.
By the appellant.
Wife.
By CMAP.
CONTC.
Pilot.
Number?
CONTC number 3196 of 2024.
96 of 2024.
It's a second contempt.
So stop. List this matter on 1 week along with and so alleging disobedience of violation of this court's order dated 25/4/2023 passed in the present appeal. Stop. List this matter on 1 week along with CONTC number.
So
Where does he reside?
only one contempt is pending or another one?
First contempt is disposed of with a
Okay.
direction, and the second contempt.
This contempt is pending.
Where does he reside?
My client resides in USA.
In USA.
The order itself is the invested amount that has been with interest.
So whatever it is, he was directed to pay 30, 25, 25. So that interest hardly matters to him because he has not paid that amount. So
Right.
that 30.
30, yes, 80 lakhs quoted. 30 was initially the
No, we have understood. We have
question of
understood.
admission.
That interest
Accrued
that includes
interest.
that 80
So
included with
that-
80 lakh. That
Judgment
is
has been paid
that is made.
along with the accrued interest. by
We have
accrued-
understood. He has interpreted the order without taking a clarification from the court.
Right.
So that is all right.
Even if the stipulation period, which has been directed
That
to
he has
pay
not
the
complied.
50 lakhs,
All right, all
he has
I have
not
taken
paid
3
within the
months
time.
more.
Within the
All
time.
right. Come up.
We may initiate contempt proceeding against
Right.
on this clearance. If you don't comply with in the meanwhile.
Item number 17.
In case the balance amount is not paid, I mean, the order is not complied, next date we may take action in that contempt application. So please be careful.
That's a quasi-criminal proceeding. Contempt is a quasi-criminal proceeding. So you may have to keep in mind so many things.
Well, I'll take instruction.
May it please, ma'am.
16 take a big one.
The petitioners before your lordship, my lords, are photographers. 100 and
Order.
my lords. It was argued if your lordship just
No, it has come for order for what?
order. It has come for order because my learned friend, somebody filed an application. IA.
Many persons have filed. There are at least same person has filed 6 applications for intervention. Or
No,
the different
different.
persons.
Different application. One intervention by the person, those who
This
have
was
criticized
actually your
I-
lordship had
987 of 2021.
one
That is
one
the
minute
IA.
before
For the purpose, orders.
before
That is filed by the member.
application for intervention was filed, and then probably an application for vacation.
The last occasion, it was.
And then your lordships had placed it before the bench
And therefore, since
presided by Honorable Justice S.K. Sao and Honorable Justice C.R. Das. Probably because in the earlier order passed by Honorable Justice erstwhile Chief Justice Muralidharan and Justice C.R. Das was a member. Probably, my lords, for that reason your lordship had sent it there. So there, my lords, the order of Honorable Justice, that division bench is there, my lords. A date was fixed for hearing of the matter finally. Then, my lords, it has come before your lordship. It came once, my lords, I took a passover, I took an adjournment for a week. Well,
Since it is
if
for
your lordship
final
thinks
hearing,
it's for
I
hearing,
just
then
submit. Your lordship
For-
can heard this matter. If your lordship permit me 5 minutes, this writ appeal is not maintainable. Because they have agreed to the new guideline in another writ petition which has been heard analogously. That is at flag Y.
let me
If your lordship's brief.
let me clarify, my learned friend. It was
So therefore, it was not
it
been
was
challenged.
also argued before your lordship for, my lords, a substantial length of time. Then your lordships took a view, my lords, it fell from your lordships that we had to come with some Supreme Court judgments, because the only thing that was stopping in the way now, after 30 years of, my lords, practicing that trade of photography, my lords, it's our livelihood at stake of 154 families. Already we are, my lords, the order of this honorable court was there that they had to make arrangements for to adjust us. And on the teeth of that, they have come up and filed affidavits, counter affidavits saying that no, they are not in a position to accommodate us. Our problem is now after 30 years, they're asking us to get a matric certificate. Matriculation certificate, my lord, that was the only hitch in our. We are willing, the rest of the conditions we'll comply. There's no difficulty. It's a question of livelihood. Your lordship has heard it. And our application under the earlier guidelines of 2006, 2007 advertisement under the 2006 guidelines was kept pending by the Archaeological Survey of India, my lords, and they did nothing on to process our application. Finally, a new guideline, my lords, amended guideline comes in 2017. Under the 17 guidelines, they bring in another stipulation of matriculation, my lords, which is.
But why was the matter placed before that bench?
My lord, that is your lordship.
For recall of that order.
We are not sure of the minutes, my lord. We have not seen the minutes.
Wanted recall.
The 28/9/2022, in that order, it was directed they will be allowed to, subject to 78 would be the ceiling and it will be regulated by the administration. So that is creating problem because.
No, but that is an interim order.
Interim order.
So if it's finally disposed of.
Yes. If it is hard finally, nothing.
No, it is stated that when counsel who have filed the interim application for recalling the order submits that if the matter is heard on merit, then he may not insist on placing the interim.
Marriage.
That is right.
Yes. It is a hard finally. If your lordship permit me, what the illogical thing is, the inconsistency is two matters were heard analogously. One petition filed by them,
All right.
another petition filed by the license.
Here the matter. Give us a date.
In both the matter, if your lordship permit me 1 minute.
No one.
We'll hear.
They have not challenged that, therefore.
All right, we'll hear you say that.
When you want.
Any date.
Only 14th I'll have some difficulty, 13th and 14th. Any day, either before. 9th August.
Jointly requested place this matter on 9/8.
9th is a Friday.
9th
is a Friday.
Oh, 9th is a Friday.
8th. Then 8th.
8/2024. To be taken up at 2 p.m.
Grateful.
One more.
issue has been settled by Honorable Delhi High Court. That order was already there on 29/1. Yes.
Your lordship may direct that let it come under admission.
Lordship was already fixed up at 2 p.m. for hearing.
2 p.m. that. Yes. 8. 2 p.m. your lordship may indicate.
Item number 18.
In this case, my lord, I am for the respondent number 1, my lord. Though my name is reflected in the list, my lord, I will file Bhaklata number today, my lord, on behalf of the respondent number 1. So I pray 2 time to file objection to the limitation petition, my lord.
No, but we are curious about the fact that even without your Wakalatnama, your name is being reflected.
My lord, as per the order passed by this honorable court, my name is reflected. I have not filed the Bhaklatanama. My client has also supplied the Bhaklatanama yesterday. Today I will file the Bhaklatanama. So I pledge let the matter come on after 2 weeks. I will file objection to the limitation petition.
No, but why your name is being reflected?
My lord,
you are not a lawyer.
I appear in the writ petition.
What is the delay?
Delay, my lord, 582 days.
Including that COVID period. Including that.
Sir, all right. Mr. G.P. Samath, learned counsel states that he has instructions to file Bagalnama in this case on behalf of the respondent.
My lord, one.
The respondent number one. So he also submits that he shall be filed as requested on behalf of respondent number one, list this matter on 2 weeks.
My lord.
Yes.
I have received. I have also received the copy. Both.
Student counsel for the Mr. So has already received copies of the writ appeal and the application seeking condonation of. Yes.
Item number 19. In 19, the lordship has already issued notice on the question of limitation. Yes, ma'am. This is the regularization matter of the workers employee that has been fixed to 22/8/2024. 532 of 2022. 432. Oh, sorry, 432 of 2022.
Waiting disposal of. Give the number.
432 of 2022. WA.
432 of 2022 and other analogous.
Yes, ma'am. Other 22, ma'am. 22 August.
Item number 20. Item number 20, may I please, madam? I am appearing for the respondent number 1. Kindly 2 week time for filing of objection. Kindly 2 week time for filing objection.
Have you appeared or will appear?
Appear file bhinama.
What is the delay?
421 days.
I have requested on behalf of the
Mr. Barik, yeah, Mr.
Madam,
Barik.
Seske Barik.
respondent.
Already filed bhinama.
All right, all right.
Sole respondent.
Sole respondent.
4 weeks. Time is allowed to file objection to the application seeking condonation of delay. List this matter on 4 weeks.
Item 21. Obliged.
I'm for the respondent number 1, my lord. File the objection, my lord.
What is the delay?
122 days delay excluding a appeal days.
We normally condone, madam. We are condoning the delay, we will hear you on minute. All right.
Right.
You are Miss
Pipi.
Miss P.P. Rao.
Ma'am.
So delay is condoned. We'll keep it for fresh admission on 14th. No. 13th. 13/8. Serve a copy.
Copy, my lord.
Copy of the appeal memo may be served.
Yes.
There are also connected matters. She must be appearing in first case.
Madam, you're there. Are you appearing in the any of the other matters?
No, my lord. First matter.
Only first matter.
Only first matter. 8 appeal number 887. 887.
So this one says item delivered.
Well,
This also says no, item bagged. This bag means sent type of thing. So otherwise say delivered bag, we presume it means that it has been sent but not
Transit.
transited. This one shows delivered. So this one delivered. This one bag. This one. So, so this one. So what is the delay in 1631?
1631, my lord.
Yes.
There is a delay of 210 days.
So all can come on the same day. On this one. None appears, second one, 1631. None appears for the respondent when the matter is called. List the case along with WA number 887 of 2023 on 13/8/2023. 23 full stop. Next also WA 1632 of 2023. None appears for the respondent when the matter is called. List this case along with writ appeal number 887 of 2023 along with the postal tracking report. WA 749, same thing. Along with the postal tracking report. And this one, none appears for the appellant, respondent when the matter is called. List this case on the first order on 13/8/2024 along with WA number 887 of 2020.
Item number 22.
Here the item has been delivered, my lord. And the delay of 467 days, my lord.
In connected matters? 22. Connected matters. 400.
22 only for regularization of service.
So is it connected with that?
Whether contempt matter is pending.
That is with our side.
Instruction I don't have, I'll verify that.
If the contempt matter is pending, then you serve a notice on him. Great. We'll take up the matter tomorrow.
Tomorrow.
Inquire. This matter tomorrow for learned counsel for the applicant to verify as to whether any contempt case is pending alleging disobedience of this court's order, which has been assailed in the present writ appeal. Full stop. This is for the purpose to ensure that learned counsel for the petitioner who is pursuing the contempt matter, if any, may be informed about pendency of the present appeal. Within the appeal with limitation application.
It's kind and less special, otherwise they will not know.
Item number 23.
Item 23 tomorrow.
Tomorrow.
Item 24.
May I please, Lords? Here, I have filed a IIA for recalling up order dated 19/6/24, my lord. In fact, I have received the counter, but I have not filed the rejoinder, my lord. The matter involving repairing of the canal for supplying of water to the paddy field, my lord.
No, you may not have filed a counter, but you did not appear on that date.
My lord, that was my mistake. In fact, I will missed the list, my lord.
Seek review of the order.
My lord, I have filed the latest position showing the photographs along with the rejoinder, my lord.
Sir, why did you file this writ petition?
I have filed the recalling of that order and hearing of the.
We are asking about why did you file the writ petition? For repair of that canal.
Repair of the canal.
So you could have filed a review application. What is this practice?
Because this is.
And why this recall order petition has been filed?
Because in my absence, the order was passed, my lord.
Therefore, you should recall the order.
I pardon, my lord.
If there is any mistake, you're supposed to file the review.
I admit that I had missed the list.
You don't appear and you file an application for recall. And do you understand the circumstance in which such applications are filed?
In fact, this is a PIL.
This is PIL, therefore you can do anything. Do you realize what have you done? We were under the impression that some order has been passed by us behind your back. You were not there.
No, I admit my fault, my lord. I admit my fault. I was absent during the call of the matter.
Present application seeking recall of present writ application filed in the nature of public interest litigation under Article 227 of the 226 of the Constitution of India, seeking recall of the order dated 19/6/2024 passed in WPC number 20522 of 2023, and the instance of the petitioner is totally misconceived and is dismissed with cost of rupees 1,000 to be deposited in the account of High Court.
My lord, this is a PIL, the cost may be because the poor petition is poor, my lord. They are seeking the interest of the public, my lord.
Item 25.
My lord, I am for the caveator, my lord.
Therefore, he has pled away.
My lord, this particular issue has been decided in writ appeal number 412 of 2024 by your lord.
Where is senior Mr. Mishra is not doing this case? Should be here.
Yes, where is the order?
My lord, I have
What is this noting? IA 2151 of 2024 amendment of delay. What is this new type of IA? What is fraudulent thing? You want your case to be dismissed for default?
I missed it, man. I beg your pardon. Right.
They given some order.
So where is the certificate?
In fact, the condonation of delay is there for, in filing the writ appeal.
How much?
11 days, 10 to 11 days.
Condoned. Then
Then, my lord, so far as the writ appeal is concerned, my lord,
Where is your certificate?
that certificate, my lordship sees. My lord, page number, my lord, 21 is the +2 art certificate. My lordship sees, page 21.
Originals, where is your original certificate?
The original, I'll produce, my lord, original, take instruction.
It is squarely covered by this order.
My lord, I'll just verify and.
No question of verification.
If your lordship may kindly pass it over for a
What for?
only to go through the judgment. Pass it over, my lord.
There is no judgment.
No, the order.
See, we'll give you it's a 4-line judgment order.
Paragraph 5, you see.
Yes. Well,
all right. Since you don't have certificate, you don't have any case.
But if your lordship may kindly keep it to some other date, I'll produce the. I'll just verify.
No, you cannot produce it before the appellate court.
Well,
if you could not produce that before the writ court, then how can you produce before the appellate court?
And if you had, you would have stated that also.
Yes.
How can you take instructions now? Because that is the
Correct.
main point.
Correct. But only I'm seeking for a passover, so that I'll just after lunch, if your lordship gives.
All right, tomorrow.
Tomorrow.
Yes, ma'am. Obliged.
Lord, a copy of the writ appeal.
I will, sir.
I don't know, 26.
For the caveator.
In item 26, already lordship has dismissed similar matter. I have given that copy. And it has been also confirmed in the Honorable Apex Court.
Same order is under challenge, 18/4/2022.
Yes, ma'am.
Same order, Mr.
The file ରଖିଥାନ୍ତୁ କାଲି ଦେବେ.
Same order, 18/4/2022 is challenged in the present appeal.
No, my lord. In the present appeal, the similar issue, the order dated 2/7/2021. Your lordship can find it from page 16. Ma'am.
Previous.
Sorry.
Previous.
Sorry, ma'am.
ଯୋଉଟା ରହିଲା କାଲି.
Sorry, madam. That
14/7/2022.
Your lordship, page 26. 14/7/2023.
Is it this matter you'd given us a handful of yesterday you had given? Same case or this another one?
Supreme Court, as well as the reproduction.
Correct. ଅଛି ସେ ତାର ଗୋଟେ ଥିବ judgment list. ଏଇଟାରେ ଅଛି କି ନାହିଁ ଦେଖିଲେ in the second copy.
Page 15. Page 15.
Oh, see, the state has challenged on order dated 14/7/2023, which is in the light of the order passed in WPC number 26692 of 2000.
Yes, madam. That is Samarendra Naik.
That has been affirmed by Supreme Court.
That has been upheld by the Supreme Court.
Page 15.
The state of Orissa in the present court appeal has put to challenge an order dated 14/7/2023 passed by learned single judge of this court in WPC number 25492 of 2022, whereby the said writ application has been dismissed in the light of this court passed in WPC number 26692 of 2011. Full stop. This appeal is barred by limitation, and accordingly, IA number so and so has been filed for condonation of delay. Full stop. Next, it is admitted that the order of this court dated 18/4/2022 passed in WPC number 26692 of 2011 has been affirmed by the Supreme Court in court by an order dated 10th October 2022 passed in SLP bracketed civil diary number 22626 of 2022. Stop. Next. In such view of the matter, while condoning the delay in preferring the appeal, this appeal is dismissed with the light of the Supreme Court's decision in case of Supreme Court decision, Supreme Court order dated 10/10/2022 passed in SLP civil diary number 22626 of 2022.
Have you entered appearance for the respondent?
Heard so and so.
Aji, Naguru. You file it, Kali, these items. I know, but this paperless, what is the meaning if they file documents in court?
Item 27.
The Lords, the petitioner has, the appellant has sent a message to me today that she has been hospitalized at Burla Hospital. She has requested the court with a written letter or WhatsApp message that you will request the Honorable Court to dispose of my case.
So if we decide to dispose of your case on merits, then you don't have any case here.
Yes.
It is not easy for this court to dispose of your case.
She has
And no one's sentiments can govern the decision of the court.
What did you say? She has been assaulted. She's in hospital.
She has been admitted to yesterday
Yes, for what?
for a cardiac, for a heart problem.
Heart problem.
Right.
So she's unwell. She has been admitted.
Admitted.
All right. So that is why she wants early disposal. They are waiting
Yes.
for her.
So her brother has sent the message that if the case will be disposed of and some money will be allowed, then this will be utilized in
For her
in her treatment.
So now your instruction is from the brother of the friend. Resolve it. Have you put your signatures? Have you given? Have you
Have you signed on the documents which is necessary for release of the money? Fix the date. He was appearing. He said he will sign. And now the case has been adjourned. 5 days have gone.
That by virtue of the earlier order, he was fine.
Which order?
Order dated 9/2/2024.
What did he sign? You're saying because the lady is not cooperating, that is why he's not signing? You told us that on the last date?
No, he was gone to the bank. By virtue of that order, he was gone to the bank.
He or she? He went to the bank.
Nominee.
Yes. Bank officers did not allow him to sign.
May I assist?
Yes, of course.
My lord, your lordship may kindly see my the affidavit which I have filed,
Yes.
the regional manager. There they have signed and we have processed as per the previous order of this honorable court. Annexure R1 may kindly pay. R1 where it has been processed because there was an earlier order to give him 1,50,000 to him and rest money to Mr. Naik's client. The appellants will get rest money and he will get only 1,50,000 as per this honorable court's order. That is our annexure R1, A1.
All right, do it first. We will ensure that that amount is also. How much total? How much is the total amount?
Total amount is 9,17,500.
Do it first. Do it first. Comply with the order.
So what,
That you do.
as per that order, whatever amount she has to get, please release that.
Yes, that is
Alright.
ready. That is ready.
Release it
Yes,
What time?
within 3 days, my lord.
Within 3 days.
Thursday.
As jointly requested, let this matter on Monday. Monday within first 5 cases.
By issuing a draft, my lord.
It is stated by Land Council appearing on behalf of the bank that by the next date, an amount of rupees,
What is the amount?
Amount is 7,96,350 in favor of the appellant.
7,93,350 shall be released in favor of the appellant, and rest of the amount shall
Amount 1,50,000 in favor of
rest of
the
the
nominee.
amount, that is 1,50,000, shall be given to the nominee. So stop. Land Council for the nominee has assured that the amount which he receives, said amount of rupees 1 lakh, which he receives, shall transfer to the appellant if he demands.
So for the appellant's thing you release.
Yes.
On Monday further orders will be passed. All right.
My lord, this draft is ready. Today I have telephoned. Them. They have said we'll make the draft ready and we'll hand over the draft.
You go to the hospital and give it to her. Because if she's in the hospital, she can't take.
My lord, because where she is, that is not.
Which hospital?
Yes, see.
Let us see if it is there.
My lord, the brother.
Because I think the bank has for senior citizens, you are supposed to visit their house and
Yes,
give
my lord.
documents.
That's right.
Yes, where?
Oh my God, it is in main.
Wasting time of the court, Mr. Naik. Hospital, which hospital? SCB?
Sammaleshwari clinic.
In Sambalpur.
Heart doctor. In the
Even doctor, we are not interested. Which hospital, which place?
some at Burla mill. Burla.
Now he's telling Sambalpur again.
Sambalpur.
That's why my lord, brother may be directed to expedite the matter. Brother may be directed so that he can release. Brother authorized by the brother to receive the draft.
By the brother.
No, by the appellant to her brother to receive the draft from the bank, my lord. Draft,
We will not
draft
say
we have
anything.
made ready.
We will not say anything.
Procedure you follow
You
and
do
hand
whatever
over.
you want.
She's a senior citizen, do whatever is as per law.
One
But by next date, you have to inform that it has been handed over.
will go. Well, because of her.
That is up to you. You can ask
She's
for
not-
authorization.
She is not staying.
See, we will not hang you if you say that if, despite your all efforts, you could not hand over. But this is our
And that's why-
earnest request to you and your client to ensure that the bank draft is handed over to the applicant.
then 1 week time may be granted because.
No, she's
because-
ill. She's
because
ill.
if she is not staying,
Sir, counsel, sorry.
You've heard she's ill.
Let us assess your conduct in the meanwhile.
yes, madam. By Friday, madam.
No, it'll come up on Monday. So you have time till Monday to hand over and produce the document on Monday.
Item 28.
We are filing the compliance affidavit
This is
In-
related to
in-
the jails.
order dated 61, dated 2/7/24, my lord. Today we are filing, we have filed it, e-filed, and it has not come to the record. I have sought copy on my learned friends.
What is that?
That is jail reforms, my lord. We have,
No, what is your there in the affidavit?
my lord, I have got a copy.
Photocopy.
Yes.
May I request one thing? They are just giving me this copy. I'll make a short convenience note because there are other issues also which have come up. So a short date,
What are they?
those jail reports and all, they have been mailed to us yesterday night. Now, like Raulkela, there is an issue of overcrowding. Then that open air jail, there are a lot of issues which we are seeing, which needs to be actually comprehensively addressed. Your Lordship should recollect that jail, there were a lot of complaints. Now the next report was.
Where is that open air jail?
That's near this some hospital. It's near this High Court. It's very close. Between Cuttack and Bhubaneswar, en route it falls.
Between Cuttack
And Bhubaneswar.
Bhubaneswar. How far?
It would be about from here, it would be around 20 kilometers.
Are you sure? Between Cuttack Bhubaneswar, if it is
That's
near
our
Stam,
hospital.
it'll be that side beyond.
No, it's on.
Home hospital is in that.
Chandaka.
Pitapalli road, my lord, from Chandaka
Oh,
to
Pitapalli.
that, in between that, around 15 to 20
Around
kilometers from this place, more. 20 kilometers from this Cuttack.
So DLSA Bhubaneswar has.
What is the system? In the open jail.
No, open jail, it's first the problem is that they're not filling it up to capacity. That's one issue.
No, what is the system first? See,
So,
what is the idea?
The UTPs, mostly it is to be filled up by convicts. The rules say
Right.
the UTPs can't come in there. Now, the system is that they will come there, work for some time and then go back. So that's the open air system that is being followed
That
here.
means they can reside in the homes during night and
Yes.
during the day they will
They
come to
come
the
and-
jail and do some work and go back.
Go
So
back.
they have to do it every day.
Other way.
So otherwise, they stay there and go out for
They
work.
stay there in the open jail. They
And
night.
go out in the
In
daytime. I'm sorry.
they go,
That's
they
the
work
reverse.
they stay with the family, they work
Yes.
and they come back.
Night they come back.
Night they come back in the open jail. This should be the.
So this is the system. I'm sorry, I said it the other way.
Therefore. All right.
But there are problems regarding infrastructure and other issues which were highlighted earlier. The recent report also has those kind of problems. So those have all come on record.
Where is that scheme on the open jail? Do you have somewhere?
No, regarding Jamujhari, main problem was CCTV, I think.
CCTV and bad behavior by the jail superintendent. Then kitchen facilities are not proper. In fact, if you
there
should
also.
recollect the last report, we had given all of that. Now they have answered some of them, but I'm told that the recent visit also has a lot of adverse comments by the DLS. So we want to just see it and also cross-check it with the legal aid.
You have a physical copy, or I mean, you have.
Yes, I have given.
All right. Affidavit is said to have been filed on behalf of opposite party number 2 online.
We have filed and I am giving a copy now.
Today.
Yes.
Online today. The affidavit is not there on the court. So,
I have soft copy on my lord, soft copy on my friends.
soft copy.
Yes, yes.
Soft copy of the, a hard copy of the said affidavit has been served upon learned amicus curiae today itself.
Yes.
Learned amicus curiae seeks adjournment to consider the said affidavit for effective assistance to be extended to this court.
Sure.
The hard copy, a hard copy of the said affidavit has also been filed in court, which has been taken on the court.
A short date may be fixed. I'll
This
assist you.
matter on. How much there? 2 weeks? Who had visited that jail? The Secretary District Legal Service Authority.
District Legal Services Authority, Khorda. Secretary, District Legal Services Authority, Khorda at Bhubaneswar.
In court we stand and scan to the said affidavit to be part of the e-brief. Yes.
29. Since my lord is adjourning it by 2 weeks, can I make a small request? In this affidavit, all that they are saying is we'll do the needful, but no specific timelines are given. So my learned friend can at least try, because 2 weeks, many things can happen.
I will try. Yes, my lord, I will try the time to give some timeline to wherever we have not given.
See, once we give timeline,
Yes, yes.
that will be very difficult for you.
Yes,
Because we will start monitoring, following,
My lord, my lord.
and then punishing people also.
Yes, my lord. Yes.
If required.
So you should do it and inform us that you've done it.
Yes, yes.
We'll do something. Do something.
Grateful to you. Item number 29.
Look to serial number 20, order number 20. This one is page 26 of your Lordship. This matter was hard time and again.
Poorhouse.
Page order dated 24/6/2024. This bench.
Item number 29.
Order dated 2/7. This has this note.
20 PS.
This has the noting order may be seen.
20 or 21?
20. 20th, then I'll take 21. 20. Let an affidavit be filed by the Secretary Orissa State Housing Board, Bhubaneswar, giving the names and address of the persons who are holding the post of Chairman and Managing Director of Orissa Housing Board from the date of passing the order, that is 6/7/2010 till date. The said affidavit must be filed such and such. The Secretary of Orissa State Housing Board shall be required to be personally present on the next date. The court is prima facie satisfied that not only those contemners have deliberately disobeyed the court's order in WPC number so and so, and subsequent order passed in the present contempt application, they have attempted to mislead this court to avoid the rigors of the contempt case. On the next date, court will consider the issuance of notice to the all such persons responsible for deliberate disobedience of the court's order. The next date, 2/7/2024, the Lordship passed this order And at this stage, if your lordship will look to the operative portion of that order, the senior counsel appearing for the housing board has submitted that sincere steps have been taken to get the matter for reserved by offering a plot to the petition number 3 and thus arrive at an amicable settlement. In so and so, the Secretary of Housing Board is present in court today. Lordship directed matters to be listed today on 37. Now, in the meantime, of course, my client had made them a time and again. Ultimately, they called a meeting. And in that meeting, of course, in presence of Mr. Kanungo, in his office, they offered 3 parts. Parts means that is that housing scheme which is yet to be started. One is disputed. The other one is a long distance. That too at the present market rate. But so far the plot which was allotted to the petitioner way back in 2003, that plot is still available. Now they have filed an affidavit today that will take permission from the government to give that particular plot to the petitioner. So therefore it requires the permission of the government. But that very much plot, that scheme itself, after getting permission from the government, that floated it. And this allotment has been made to the petitioner. That is still available.
But I think in between they had cancelled that. So maybe
They have also revoked it. They have
that is why
revoked it.
permission is
And they
necessary.
have revoked it. Again, because your lordship's interference, they have revoked that order. Order of cancellation, order dated.
So what is to be done today?
So,
my lord, what had happened? We had offered him 3 alternate. One is a plotting scheme, 2 are flats. He refused, my lords. It's well within his right. So, my lords, he wants that same plot which your lordships had directed. For that, my lords, there is no housing scheme there. We need the permission of the government. And we have written, my lords, I have given annexure A. We have written to the government explaining the entire situation that this honorable court's order has not been complied with. And because of that, a contempt application is going on. So, your lordships may kindly see annexure B series, my lords. I'm just placing the relevant portion of that scheme. In order to comply with the matter of this honorable court, a meeting was held. Thereafter, we have written to the government. However, the petitioner did not agree to accept any of the 3 offers made by OSHB and insisted to take the plot at Unit 6, Ganganagar, Bhubaneswar, as per the direction of this honorable court. Since the petitioner is not agreeable to accept the proposal of OSHB for allotment of plot in the 3 proposed housing schemes and insists for allotment of plot in Unit 6, Ganganagar, Bhubaneswar, which cannot be acceded to without permission of the government. In the above circumstances, it is requested for necessary instructions of the government in the matter so as to comply with this honorable court's order passed in contempt number such and such, and for filing affidavit on 37/24. This letter has been addressed to the Director Housing ex officio additional secretary to government of Orissa, my lords. So, my lords, the government's permission is necessary.
So when was that letter issued?
My lords, this letter was issued on 25th.
On 25th.
Yes.
The
meeting took place on 20th.
Today is 30th.
Yes.
We can wait for some time. All right. You can convey to them.
Yes, sir.
That we will not pass any order in the contempt proceeding, directing them to grant permission or not to grant permission. All right. It is up to them, the government. But you can assure your officials, those who are required to.
She is present in court today.
All right. So, she and all other officials, those who were heading the body, we have in the present contempt proceeding, our jurisdiction is limited to the extent of punishing them if their act is found to be intentional. All right.
Yes.
So we have before us the names of all the officials. We don't know which officials shall be punished, which shall be exonerated. But depending upon the individual, it's a quasi-criminal proceeding. We can punish them.
Yes, certainly, ma'am. Certainly, ma'am.
So you do whatever you want to do. it is stated by Mr. Kanungul and senior counsel appearing on behalf of the petitioner, on behalf of the contemners slash, what is that development authority? TDH.
Orissa State Housing Board.
Bhubaneswar State Housing Board, that a proposal has been made for making available the plot which was originally allotted in the name of the petitioner to the state government.
Petitioner number 3.
Whitson.
Two have taken back.
Number 3,
Whitson.
Give the name also.
namely,
Name.
and so
Alek Padhya.
Oleg Puri.
As-
Dr. Oleg Puri.
Doctor.
as in the facts and circumstances, the permission of the government is required. Full stop. We have formally not initiated contempt proceeding against the officials in view of the assurance which has been given on behalf of the contemners to resolve the dispute, resolve the issue which got complicated because of certain developments, amicably. First off, we make it clear that once we are satisfied that this court's order dated, what is the date?
Date is 20
The original order.
6/7/2010.
6/7/2010 has not been complied with. 6/7/2010 passed in WPC number 13238 of 2008 is not complied with. The court shall have no other option left but to proceed against the officials in the present contempt matter. Let this case on 2 weeks.
Your Lordships may give us 4 weeks. Your Lordship.
No,
Already right.
2 weeks.
Item number 30.
2 weeks. Fixed date.
2 weeks date you will get. And what is this writ petition?
Writ petition.
That is a disposed of case.
That is the order.
Well, that was
Application.
this case filed way back in 2010, which I don't know why it was not pressed for recalling that order because there was no house available. That
You as the petitioner, you should tell us
yeah,
why it
yes,
was not pressed.
I understand, my lords. There was
He has not placed that.
See, personally speaking, I am surprised over the fact that how audacious are they?
Well,
How can they think of disobeying the court's order like this? The manner in which it has been done. Yes.
so, my lords, and what is happening, my lords? The present officers are facing the music.
No.
My lords, they were not aware of this
We
order.
guarantee, Mr.
Yes.
Kanungo, that if the present officer is guilty,
Ma'am.
the present officer shall be punished. If her predecessors are guilty, they will punished.
Ma'am.
Because contempt is individual,
Capacity.
based on individual conduct.
Yes.
If it is not that, because Andher Nagri Chaupat Raja, whosoever is present, punish him. This rule will not apply.
Certainly.
Whoever has committed shall be punished.
Yes.
And we have given enough indulgence.
Certainly, my lords. Certainly, my lords.
Yes.
Item number 30.
Nothing, item number 30, lordship sir, please.
Well, personal presence maybe not.
Personal present. You be here next
Next
time.
time.
What is your feedback? Whether it will be done or not?
Yeah, my lords, they are following it up with right earnest with the government. They have already explained the entire scenario. This is what has happened. And please see that necessary.
Lordship had directed me to obtain instructions with regard to the status of that 26A, capital A, application under section, I mean, under the Wildlife Protection Act, and on Thursday, Lordship, the DF of Satkusia, who is in charge of that, he had telephoned me and also sent a message that he will give me instruction by today, by Monday, because the matter is listed today. And he had also said that his father was ill, so he was in hospital. But today, I've been trying to get him, I'm unable to get him. So,
My lord, actually the fact relates to the year 1999. And in 2008, the matter was disposed of by this honorable court. They took it to Honorable Apex Court. And then it was remitted to this court. And this is the order passed in 2015. And they have simply disobeyed.
he was
Let
saying
us
that
see the order again.
he was saying that some orders have been passed under section 20. There has been some notifications for which this area comes within 1 or 2 kilometers radius. That is why he wanted to give me the documents along with the instruction.
No, let me see the order again. Where is the order?
Order is, because look at.
The order is 11/2/2015 and another is 95/94/2015.
No, you are alleging violation of which order?
Violation of order dated 9/4/2015. That is the latest modified order. Annexure 3, my lord, page 14 to 16. Page 16 is the order, my lord.
So this is in a disposed of, in the disposed of writ application. There must be another order.
Yes, ma'am. That order is dated 11/2/2015, which has been annexed to the review petition listed along with the content
No,
petition.
it is there at page 11. It is there.
Yes.
The land in question is a free land, so they allowed him to cut the trees.
Yes, ma'am. Land is admitted free land.
So
But
by
because,
modification of order, it was observed that
yes, it comes nearby the
that order,
No.
simple order was the permission was given to cut the
cut the
trees.
trees.
But there was nothing about TT permit.
Yes.
So that by way of modification, they have said that, where is that again?
So the trees have been cut.
No, my lord.
No.
It has not been caught because they did not allow.
Oh.
They did not allow.
Yes, my lord.
I think last you were saying that what is the use of cutting if you can't carry them out?
No, my lord, it has not been caught because
Because
they did not allow to permit to issue transit permit.
exactly.
Yes.
So if the transit permit will not be issued, it will be
That means
destroyed.
that means the petitioner has not cut the trees because transit permit
Petitioner,
was
the
not there.
cutting
Yeah.
responsibility is of the petitioner.
So don't say
But
they don't
unless
allow cutting.
the transit permit is processed, so the cutting will be simply a destruction and will be
The
a
problem
hospital.
is happily you took away the order for only cutting the trees.
No, my lord. With
Is that the order of 27? What is the 27? No, previous order.
previous order, it was to cut the trees.
Yes, exactly.
But I prayed for the modification. Unless the transit permit is issued, it will not be done. And that was also not directed to anybody.
to issue transit permit. That's why a modification.
Exactly. So you went off with that order to cut the trees.
My lord, cutting will be a
So there
destruction.
is no
to
contempt if you look
No,
at it.
it is 11-4, my lord.
Yes.
9-4.
What problem do you have?
Yes.
What problem do you have?
No, our case is that because it comes within 2 to 3 kilometer radius of the reserve forest, which has been declared as a reserve area, so we cannot give permission to remove the trees from the by issuance of a transit permit.
Where is that? Right. So you should have challenged the order.
I think it's gone to the Supreme Court.
No, we had gone to the, so we are challenging the this review petition 41 of 2015. We have challenged that order in this review application. So that your lordship is session of this
No,
matter.
just a minute. I think you had gone to the Supreme Court. Some order was passed that you can just, or am I mistaken?
The
Getting
Supreme Court, my
confused with
lord,
so many matters.
directed remitted the matter to this honorable High Court, and the High Court disposed of the matter.
Oh, so that order was after remission?
Yes,
After
yes,
remand?
yes. All the it's after remission.
So after remand, he was permitted to cut the trees?
Yes, Lord.
Okay.
On the ground that the
Yes.
concession given by state governments, also central government.
And now you filed a review that concession was not given.
You are never instructed, and central government says no such because it's a state CA. We have sought for permission from.
Oh, so your counsel stated that we have nothing.
He notified the area.
We have nothing to do, so it is the case of the central government. Central government said we have no objection.
Yes.
Thereafter, the court said that you asked the counsel who had made that submission must file a personal affidavit.
Yes, no.
So now the counsel
Who is giving you instruction?
The revision, the DFO under whose jurisdiction this reserve forest comes. DFO Satkosia, wildlife
Ask him to be
sanctuary.
here.
No.
Ask him to be here.
Yes, ma'am. Next week also fix a date so that he will come along with all the records before us.
Do not find any justification for non-compliance of this court's orders. This court's order dated 11/2/2015.
9/4/2000 also. Modified order in 9/4/2000.
Just a minute. 11/2/2015. Read with the order dated 9/4/2015 passed by a division bench of this court. Stop. The court forms an opinion that the petitioner has been made to run from pillar to post to ensure that the aforesaid two orders are implemented. Stop. We express our displeasure for the manner in which the department has proceeded to department has been insensitive in carrying out the aforesaid orders of this court. Stop. List this matter on did the forest secretary come by?
Because the DFO has filed this review application. He has to grant that permit only.
Let the divisional forest officer
Satkosia, DFO Satkosia to remain present before Lordship along with the records.
Be personally present in court and furnish to this court the names and addresses of such other officers who were required to comply with the aforesaid two orders or orders passed by this court for this court to consider initiation of contempt proceeding against all of them. 1 week. 1 week,
Next Tuesday.
2 p.m.
Item 31.
In item 31, respondent has died. So I have written 3 letters to the no steps has been taken for filing of the substitution. Your lordship may give me the last chance if
She was filing Wakalatnama last week.
I have written 3 letters for substitution. No steps. Only last chance may be given.
The respondent number. Respondent number. Sole respondent.
All sole respondent.
Yes.
No, respondent number.
Respondent 1 is.
Respondent 1 will two performer respondents are to
Respondent number.
1.
1 died during dependency of the present rate of appeal. So no steps have, however, been taken. Then we are just saying that it abates.
That only one last chance if they will.
No, even other, that is why operation of law.
Well,
He's ready to appear.
All right. See, there you see. No steps have been taken for substitution. And setting aside the abatement. To stop. Let this matter on 2 weeks. You are not saying anything.
well,
Item number 32.
May I pray for an adjournment, madam? I am not prepared. 32. I am seeking for an adjournment. There is some problem.
When?
Yeah. After next week, 12. We commencing from 12.
I requested on behalf of the current place this matter on
13th.
Oblige.
Item 33.
in item 33, all these cases or Mr. Sushant Kumar Mishra has appeared on behalf of respondent. He has sent a message. He is ill or seeking for some time. I am for the appellant.
If we did something.
He sent a message to my.
I requested on behalf of the appellant place this matter on 2 weeks.
Respondent.
Respondent, he requested me, I am ready.
Respondent.
Item number 34.
Along with the connecting matter.
Item 34, my lord. I am appearing for opposite part number 5, my lord. I am filing my counter reply, my lord. Serving a copy to other side, my lord.
Counter reply to what?
But the writ appeal, my lord.
Writ appeal, there is no reply required.
But he has disputed some of my eligibility criteria. That's why I filed that reply. Well, your lordship, remember, my lord, this is a common formation of common constitution. Now, in the meantime, my lord, government on 25(7) has reconstituted the common cadre, my lord. Relying on 10C. Your lordship, see the order. You are in contempt, but your lordship has passed an order, my lord.
Contempt.
There is a contempt relating to Dr. Premlata's house case, my lord. The order is there. 21(6) order. I'm providing that order, my lord. My associate is there.
No, let us see the order which is under challenge.
Yes, but yes, my lord.
Which annexure?
Page 89, my lord.
My lord, page 37 to 39.
And the most judicious order is order number 10. Dated 1/3/2024.
12/3, my lord.
Yes, where is the judgment?
89, page 89, my lord.
Which judgment you are challenging?
Yes, my lord.
Annexure?
Paragraph 5, my lord.
No, you are not challenging.
I am challenging.
Huh? You are
Me,
challenging.
man.
Where is the order?
My lord, the copy of the order is at annexure 2, your lordship.
Annexure 2.
37 and 39. 37 to 39.
Voting the index.
Yes, that is the question where the transfer order has been, writ petition was dismissed because he had joined.
No, my lord.
No.
This is a different.
Yes, where is the order impugned? Where is the impugned order?
My lord, 85 to 86. Sorry, there is 2-3 orders in this, so that's why.
No, which order you have challenged?
My lord. My lord, it is the order dated 1/3/2024. After that, there are series of orders that are passed. The single judge, the honorable single judge passed the order dismissing the case on 12/3/2024.
Mr. Let us understand which order you are challenging.
My lord. The order at annexure 7, your lordship. Page number 80. It starts with 87, your lordship.
You are challenging.
My lord.
But you yourself say it is the most judicious order. So why are you challenging that?
My lord, orders passed by this honorable court has to be called as judicious, because unless that is.
Then you cannot challenge.
My lord, it is before your lordships to determine how judicious it is.
But you have said most judicious and you're filing the appeal.
That's the way of addressing the honorable court's order.
No.
Paragraph 5 is under
My
challenge.
lord, the simple point was that.
Paragraph 5 में cheap.
My lord, the simple point was that there was a dispute that a person who is initially appointed into junior college, +2 colleges, has been made principal of a degree college in violation of the department's own direction that such persons cannot be appointed as the principal of degree colleges. My lord, what they have produced in the name of, they took the stand that they are constituting a common cadre which will be a panacea to all these problems. My lord, they took 1 year in the contempt petition to form the common cadre, your lordship. And the order that my lord and friend is producing in the name of formation of common cadre is a hogwash in the name of common cadre, your lordship. Given 3 minutes is a hogwash in the name of common cadre. It is no way close to the common cadre, your lordship. My lord, given me 3 minutes indulgence, I will call out how they have bluffed to this court in the name of constructing a common cadre, your lordship. In that particular contempt petition, they submitted an affidavit wherein they have delineated the process that need to be followed in constitution of a common cadre. With your lordship permission, I would like to submit that for your kind appreciation. 1-page document, your lordship. Another. Out. 1 page. This is what needed to be done in compliance to your lordship's most.
Mr. Please show us any illegality in the order which has been passed. You have filed this writ appeal to challenge the order.
My lord.
What is the illegality?
My lord, illegality is that this is what I was submitting, that I am appointed in a degree college, and the opposite party who has been given
What is illegal? Which part of the order is erroneous?
My lord, the point has not been gone into the merits of the case has not been gone into.
What you see, your claim has been taken note of.
My lord.
Then an order passed by writ petition has also been taken note of. Then it is observed by the learned single judge that he shall continue till the common cadre is
That is what is the
Repeat it.
contention, Your Lordship.
Just repeat.
My Lord. That is what is the contention. My Lord, the college in question is an autonomous college. Autonomous college. Now it is being managed by a person who comes from a different college, a temporary arrangement, Your Lordship. And that is what was my contention, that the appointment that has been challenged has been passed in violation of their own direction. That a person who is initially appointed in +2 college, junior college, cannot be and shouldn't be appointed as the principal of degree colleges. That is what was my prayer. And the order has been passed that a third person will continue till the formation of common cadre. Now, Your Lordship, they said that they're forming the common cadre in pursuance to Your Lordship's direction under contempt petition. And in the contempt petition, I just supplied the document that all these steps need to be covered and a common cadre needs to be prepared. And what they have right now come out with a resolution, that resolution is flawed as such, that is a different matter. But that is nowhere close to the common cadre, Your Lordship.
So you can challenge
Different cause of action.
Well, that is different. But in my case has not been adjudicated. That is my only prayer, that that particular direction, that the +2 appointees, people appointed in junior colleges shouldn't be posted as principal in the degree colleges. That particular point has not been taken into account.
But once that common cadre is there, then that point goes.
Now, that is the point. That in the common cadre, that is what is the issue, Your Lordship.
No, that we cannot go into the common cadre.
No.
Unless you challenge it.
That is what the order of the learned single judge is, that the interim arrangement would continue till the common cadre is formed, Your Lordship. Now, Your Lordship, the common cadre is not yet is formed. Yes. That is what I am saying. That is what I am saying, that the common cadre is not formed. That is what I have submitted before Your Lordship, that the steps that needed to be taken, and that is the reason they took 1 year. And what they have come out is a flawed, that's a different issue. But common cadre has not been formed yet. Because common cadre, Your Lordship, the previous affidavit they have submitted before this honorable court on dated 28/4/2024, they submitted that they are preparing 2 cadres. One for the degree colleges.
What is the provision for appointment of this post? The
72 of my affidavit.
My Lord, the rule is very clear that there will be a common cadre prepared from among the teachers, taking their experiences and the seniority and eligibility.
The rule.
My Lord.
10C.
My Lord, 10C. My Lord, page number in that page is 150, Your Lordship. 10C of the Odisha Education Act 1969.
No, that is not our question. Our question is, what is the procedure for appointment of a principal cum secretary of a college?
My Lord. And it is provided here only. My Lord. My Lord, the exact provision Your Lordship is looking for is actually missing. But I'll draw Your Lordship's attention. What are the problems in this? Your Lordship, it says the state government may by order constitute a common cadre in relation to all or any class of employees of all or any category of aided educational institutions as may be specified in the order. Your Lordship, the words are important. That is one. Provided that the state government may constitute a common cadre in relation to all or any class of employees or any category of aided high schools, that is the second point. This is about constitution of common cadre, and from here they will be selecting persons who will be heading educational institutions. That is employment of.
What is the meaning of clause 5? That negates the option of exercising option.
Yes, that is compulsory. That is
Question of option.
that is what is the point. So that they have interpreted earlier that everybody who is appointed in a direct payment post comes to the common cadre automatically. So what they have furnished right now today is meaningless.
No,
what
that I'm not saying.
What they needed to be doing.
There are 2 things.
Man.
One, this 10C1.
My Lord.
And 10C and the proviso to 10C1. they are not mandatory in nature.
They're not.
All right. It is not that the government is under compulsion to constitute a common.
My lord.
All right.
My lord.
So if the government decides to constitute a common cadre, then other provisions are to be followed.
My lord. My lord.
All right.
My lord.
So then.
My lord. I was not praying for the common cadre. My humble submission was only this, that whether there is a cadre, it is optional for them to constitute or not. They were under this court's judicious order that they have to constitute a common cadre in the Dr. Premalata.
So now the common cadre has been constituted.
They haven't constituted. That is what I was showing, that they haven't actually constituted. What they have done, my lord, is that they have tried to mislead this court.
You can, if they have not done that,
My lord.
despite the court's order, then you can allege violation of the order.
My lord.
You are challenging the order.
No, I'm not challenging. I'm just submitting that how it is related to.
You are challenging the order because you have filed the writ appeal.
No, I have filed the writ appeal challenge. Common cadre they're producing today, claiming that they have formed it, which I am saying that they have not formed.
Government is.
You are saying they have not. The resolution is here.
That resolution, that's why I passed on one-page documents, what they were expected to do.
Counsel, these are two different aspects.
Man.
One, if you are challenging the order, then common cadre should not be formed.
My lord.
Is this your plea?
No.
This is your plea that the arrangement as suggested by this court that he should continue is illegal.
The third person is continuing, not me, not the person I'm challenging.
Right.
That is an interim arrangement till the formation of the common cadre.
Yes.
That is what is the order. Wherein I am submitting that the common cadre they have not formed, that is a separate issue. And the issue that I had raised through the writ petition, that a person initially appointed in a junior college has been placed as the principal of a degree college superseding me, that particular prayer has not been taken into account, has not been adjudicated upon. And there is no clarification, even in all these matters, till date, there is no clarification on that. That is the gray area the department is playing on, and all the educational institutions are appearing on that. That is my basic.
But the person's appointment you were challenging is not the principal now. Somebody else has been.
Somebody else has been as an interim arrangement. That is the point. And the common cadre is not being prepared.
Now the role of the appellant and the respondent number 5 will be tested, will be scrutinized on the basis of this resolution, madam. The common cadre.
What do you want? What do you want?
Now, my lord, now the government has formed reconstruct the resolution, my lord, on the common cadre. Now, my lord, the fate of the appellant and the respondent number 5 can be scrutinized by the government on the basis of this.
You were seeking adjournment on which ground?
My lord?
You were seeking adjournment in the very beginning on what ground? You are not seeking adjournment.
No. I am filing counter. I said that I filed my reply because your lordship had turned to interim order was there. Your lordship had turned to page 15, my lord. For a moment, page 15 of my reply, my lord. This is the first order, 30th 11/2020.
How do you justify the order passed by this court? According to him, a person junior to him was brought and made principal of the college.
No, my lord.
Was that legal?
No, my lord. It's totally false. I am senior to him, my lord.
No.
Person appointed in a junior college.
My lord, your lordship had turned to the date of appointment, my lord.
I
have given the state counter is also there. They have given that he is himself admitted.
According to, just a minute. According to you, you are senior.
Yes, my lord.
All right.
It's admitted.
Let us understand. We are not clear on facts.
Yes.
According to you, your date of appointment is prior to the date of appointment of the appellant.
Yes. Yes.
All right. All right. What is your case? There is some seniority on the college also.
My lord, that is the point. There are two cadres.
Yes.
One is the junior cadre, lecturers who are appointed initially into +2 colleges, higher secondary schools, or intermediate schools. These are the three terminologies they are using: +2 college, junior college, or higher secondary school. The opposite part number 5, who has been appointed as the principal, initially was appointed in this +2 category. And according to the department's own rules, the persons who are initially appointed in +2 colleges cannot be posted as principal in degree colleges because the qualifications vary. In plus 2, the essential qualification is 48%.
Degree college.
My lord, this is an autonomous degree and autonomous college. This is one stage I had, but it is considered as a degree college. In this degree college, I am the person senior most of among those who are appointed in degree colleges, and the person that they have appointed comes from a plus 2 college, and if he is going regarding the date of appointment and other things, there are other difficulties I'm not getting into that. I'm on this specific principle that it is their own principle, set principle, whether there is a common cadre or not.
How the person working in +2 school
My lord,
can be transferred to a degree college?
that is what is also done without there is not very clarity. They are deputing persons from degree colleges to +2 colleges, getting them transferred without changing their nomenclature. So these
degree colleges
my lord,
must be affiliated to universities.
my lord.
Yes.
And the degree colleges
+2 colleges are affiliated to school and mass education department or the Council of Higher Secondary Education.
for the state and university.
In the state, I am for the statement.
How is this being done?
No, illustrates that we have framed in the meantime, we have framed issued a resolution governing that common cadre, how the common cadre is to be formed. Illustrates that notification is 25/7/2000.
Can there be a common cadre for the teachers teaching in +2 schools and degree colleges?
No, my lord, that cannot be. But illustrates before that, I will drop my lord's notice to the rule 74 rules.
Yes.
1974 rules.
83.
Mr. Kuntia, what happened to that composite college thing?
So,
No, don't laugh.
No, can there be any such?
Well, to that extent, some illustrates see that 1974 rules, rule 8.2.
83.
8.3.
83.
83 or what?
1974, the education, Odisha education, recruitment and conditions of service of teachers and members of that, if a lordship is holding this book, my lord, then that is page 976.
Yes.
That's got it.
Yes,
Here.
yes.
You have to write. No?
Yes, yes.
Yes.
Lords may say rule 8.3. Vacancies in the post of headmaster of aided boys high schools and headmistresses in girls high school and readers, including principals of aided college under the fold of system of direct payment for full service shall be filled up by the eligible trained graduates of respective high schools and headmasters and headmistresses of respective middle English schools and by lecturers belonging to the common cadre of the aided colleges as the case may be from the select list prepared by the selection board in the manner prescribed by the regulation framed by the select for the purpose on the basis of the recommendation of a committee to be constituted by the government which shall be headed by the director. The selection shall be made on the basis of seniority in the common feeding cadre and performance. So on. This is the criteria for filling up the post of principal. Then your lordship seen that section 8.10 of that.
There's a proviso in the absence of common
Yes.
cadre, it can be done like this.
Well, I am saying that how that post of the principal is to be filled up.
So as per this rule, the appointment of opposite party number 5 or something was illegal.
Yes, madam.
Because it says
So-
in absence of common cadre, it can be done amongst the schools only.
Yes, madam. What has happened, madam? We have issued a guideline on 38/2021. So that was quashed and your lordship was directed to frame a common cadre rule.
But this is regarding primary schools and
No, the aided school, college, your lordship.
different aided education institution. So
Aided
we
ed-
cover everything.
Yes, my lord.
no, my lord, there is a difference. I'll show.
this shall not apply to primary.
It includes only high schools and aided colleges.
My lord, there are two categories as they have themselves.
Just a minute, just a minute, just. Whole lot of confusion. To this rule 3E. Sorry, rule 2F of the rules.
Well, institution
74 rules.
74.
Well, institution means an educational are defined in section 3E of the Act.
So
3E
what is 3E of the Act?
3E of the Education Act, my lord, you also can find it from that page of that book at page.
We will take up.
My lord.
I may be pardoned, my lord. Next item we are there, you'll also may call it some other day.
All right, whenever you want.
Next 10 days after.
10 days, 2 weeks after.
Obliged.
Lord, item number 53 has already been adjourned to 7th of the next month, my lord. My learned senior for opposite party have mentioned at the mentioning hours, my lord. Only issue is, my lord, there is an interim order that has not been extended in the connected writ petition. In the connected writ petition, there is an interim order.
You are for whom?
I am for the petitioner. The opposite parties have made mention in the morning hours, my lord. The matter has already been
They had
adjourned.
not taken your consent.
They have taken, in fact, but they have only informed at 10:32, my lord, today. That is the only issue. My lord, obliged.
So the interim order is in VIP projects.
My lord, in the connected matter. Obliged.
34.
Sir, may I please? May I please, madam?
Yes, so how is this? What is the system?
Yes, my lord. Smith, for that reason, I have shown my lords that rules 74 rules 8.3, and your lords may see that section 10C of Education Act. My lord, your lords, you can find it from page. If this is the book, my lord, at 150.
Yeah.
That's got it. Education Act 10C, my lord.
So, do you have any University Service Act or not here? The University Act.
Yes, Universities Act is not applicable to the aided educational institutions.
Huh?
Universities Act, so far as recruitment of lecturers are concerned, what in respect of what is the status of these aided institutions?
Which you are saying is impossible.
No, my lord, I am clarifying.
Even if there is such law, that law is
Yes.
not proper.
My lord, yes, I admit, my lord,
Because the colleges imparting education up to degree level are different from those imparting education up to plus two level.
Yes. That-
All right.
Yes, ma'am.
So if this is your submission that Universities Act do not apply to aided institutions,
I
then,
don't-
then
yes.
where do they get affiliation from?
No, well, I don't say so. Well, in so far as recruitment of lecturers are concerned, in private, what has happened? These status of these aided institutions, initially these are the private managed institutions.
Sir, even if they are privately managed institutions, their qualification is
Yes, ma'am.
prescribed by the
University,
UGC.
they follow. That is followed at the time of their initial recruitment. There is no dispute.
So
This
where
is
is the question of common cadre? You are thinking of common cadre between, say, the police service and the doctors.
It
is like this.
You'll also see that.
Where is the question of common cadre of teachers and assistant professors?
My teachers of my common cadre of teachers in respect of that aided colleges.
Aided colleges, see, even in aided colleges must be having affiliation of the university.
Yes, my lord.
And they must
Yes.
be having, they must be having teachers of the rank of assistant professors or
Yes,
associate
ma'am.
professors
Yes,
or whatever.
yes, my lord.
Because they are governed by the
Yes, my lord. Accordingly, we have issued that till though 10C there, so no, you'll also have seen that 10C. The state government may by order constitute a common cadre and so and so, but no order was passed to that effect. For the first time on that order was passed on 25/7/2024. But constituting the common, how that inter-seniority it will be maintained. My LRC can find it from that.
Seniority cannot be there between the institute, between the teachers of +2 colleges.
No, that has been mentioned. How that if LRC may see that notification 25/7/2024.
There is no question of inter-seniority.
No, lectures of clause to college are not included. That's the point.
All right.
Let me see that 25/7/2024 resolution. We have framed. Last page 72.
Yes. So you are referring to what?
That how LRC see how that inter-seniority it will maintained. LRC page 73. The classifications at page 72 and LRC can find it from 73 inter-seniority.
Here.
Inter-seniority of lectures of non-government aided colleges appointed or regulated against direct payment post in respect of a particular recruitment subject shall be on the following order. In each category, inter-seniority shall be determined in the following manner, namely.
So your difficulty is that how do you define aided colleges? Which are aided colleges?
Aided college. You'll also see that rule 3, section 3 of that Education Act. B, man. That is the definition at 3B added educational institution and 3D college.
Yes, this is what
Yes,
I wanted
yes,
to refer
yes,
to.
yes, my lord.
Therefore, I was
Yes, yes, my lord. Your lordship,
See.
I understand, my lords, that your lordship is referring that college means the appointed against those as defined on 3D.
So whenever you refer to college
means
it
3D.
means college imparting education up
Yes,
to
yes, yes.
degree level.
Yes, my.
Yes.
3F, your lordship is C. 3F.
We will see.
3F.
Please don't interfere.
Sorry, man.
Yes. Yes, please.
So your lordship, that it defines college, the imparting higher education, your lordship, means education or imparting instruction in higher general education leading to any degree conferred by any universities established under the Odisha Universities Act 5 of 1989.
Yeah.
So this is the inter-se seniority of the lecturers who are appointed in the colleges, not in clause 2. That your lordship is asking me a question whether that clause 2 and clause 3 are, so that is not as per this resolution at 24 resolution. We have framed a guideline how the inter-se seniority is to maintain in respect of lectures of colleges.
Yes.
So that is till the first time this has been introduced. And after this, a common cadre will be formed and inter-se seniority will be formed. And you also have seen that rule 8C.
So you are going to this prepare a gradation.
Yes, yes, ma'am.
The
lecturers of the colleges.
Of the colleges.
Yes, ma'am.
So have you prepared or you are going to prepare?
Yes, ma'am. That was formed on 25/7/2024, just 2-3 days before.
All right. So the person who is the principal of the college is of +2 college, +2 school or college?
Plus college.
He was appointed as lecturer in a college.
College.
The person who has been allowed to function.
Yes, ma'am.
Yes, is he?
My lord, slight difference.
Just a minute. Just a minute. So how do you say that he is not lecturer of a college?
My lord, the person who has been allowed to function is a third party, who is an interim.
Forget third party, whether he is qualified or not.
My lord, the person who has been appointed against whom I have complained is a +2 appointee. I will show your lordship the document.
So he is not functioning.
He is not functioning.
He is not functioning. The person who is functioning is a teacher of a college.
Of a adjacent college, yes.
Then,
my lord.
Then what problem do you have?
No, my problem is that the appointment I had challenged on the ground that a +2 appointee.
So +2 appointee, that is over.
My lord.
Therefore, the learned single judge has rightly observed that let a gradation list be prepared and thereafter the
Common cadre, yes.
Common cadre shall be
My lord,
prepared.
the common cadre, they are yet to be prepared.
They will be preparing.
My lord, since 1979, they are not preparing. And this resolution is incomplete, and whatever this resolution I am not right now saying, but the only clarification that needs to be brought in as they are submitting but not admitting that there are 2 cadres. The only point of the clarification that needs, even in their own affidavit, previous affidavit, they have admitted that they are preparing 2 cadres. One is for the colleges, as my learned senior friend from the government right now submitted, that it is for the colleges. And there is another cadre in the previous affidavit, they have started the process. And so therefore, this is not a common cadre as such they have prepared. They are setting the principle guidelines to determine inter-se seniority among the lecturers of the degree colleges. My humble submission was that the appointment they had made earlier is of a person who is initially appointed into +2 colleges. So I am the senior most of the degree colleges. That principle has not been adjudicated and it has been postponed.
There is a question. That principle, every principle is not required to be adjudicated in every case. It depends on the facts and circumstances of that case. If every issue is being decided in all the cases, then it will become very difficult to dispose of cases. Yes. What is your submission? Who are you? Who are you?
I am respondent number 5.
You are working as principal.
No, my lord. I was appointed against my appointment order. He has come to learn a single judge, my lord.
All right. So have you challenged that order?
No, I have not challenged that order, my lord.
Are you happy with the order?
I am accepted because common cadre is to be formed in terms of rule
That is over.
10C, my lord. Yes. 79(3), your lordship may see.
Unnecessary. The petitioner in the present writ application has put to challenge an order dated. Where is the order?
Order dated 12 March 2024.
12 March.
Annexure 7 at
Page 89.
87 to 89.
Page 89.
Page 89.
Dated 12/3/2024.
My lord.
12/3/2024. Passed in WPC number 38391 of 2023, whereby the single judge has permitted one Abhijit Bose, admittedly a lecturer of college within the meaning of section 3 bracketed D of the Bihar Education Code, Odisha Education Act, as the principal in charge cum secretary of Kendrapada Autonomous College, Kendrapada, as an interim measure till a common cadre was framed and necessary arrangements were made accordingly in terms of an order passed in case of Prem Lata Raut versus State of Odisha. Is there any reference to this? What is the case number, order?
The WPC of Premlata Raut is WPC number 12606 of 2023.
Bracketed WPC number?
12606 of 2023.
Disposed of on?
That is not.
Disposed of on date. Stop.
The judgment is 11/5/2023.
It is not 11. It is noteworthy that the petitioner, that the appellant had questioned the appointment of opposite party number five as the principal cum secretary of Kendrapada Autonomous College on the ground that he was a lecturer of a +2 college, and after having been transferred to the appellant's college, which is a degree college, he was made the principal of the college, illegally. So stop. Next. A counter affidavit has been filed on behalf of the state of Odisha, stating therein that in terms of therein, inter alia, that in terms of this court's order dated 12/3/2024, a process for preparation of a common cadre of the lecturers of various aided colleges in the state of Odisha has been started. And and shall be finalized soon. Stop. Next, learned counsel appearing on behalf of the petitioner appellant has submitted that the learned single judge has not adjudicated upon the legality of the appointment of respond number 5 is respond number 5 as the college of, as the principal of the college, which ought to have been considered. Full stop. Next, in the given facts and circumstances of the case, when respond number 5 is not continuing as principal of the college and a person who is admittedly eligible to hold the position of the principal of the college, comma, we are not inclined to interfere with the impugned order, comma, particularly in view of the stand taken on behalf of the state government that that steps have been taken for preparation of seniority of a common gradation list, which is likely to be prepared soon. First off, in such view of the matter, we dispose of the spirit appeal with an observation that let the preparation of common cadre be expedited and completed, preferably within 2 months from today. Yes.
Unless that particular clarification, it can be inserted that.
That clarification you come, we will see. I'll decide that.
Fine.
Let that dispute arise. Respond number 5 is fine. Respond number 5 is clear. Respond number 5.
Obliged.
File up there. File.
Item number 54.
First item, 54. The first item, my lord, the facts are in an extremely limited compass, my lords. Within the time frame fixed by your lordship, my lords, the petitioner college had submitted the deficiencies, made good the deficiencies, but they had done it in a, my lords, hard copies had been given. They had not uploaded, so that is why they have rejected. Otherwise, my lords, it was, and they have admitted in the counter also that it was within time. Paragraph 7 of the counter filed by the, my lords, page 3 of the counter affidavit, pursuant to the aforesaid letter, the petitioner submitted his compliances by the stipulated time. That is on 13/3/24, received by this office, which was not disputed, but the same was submitted through offline mode, hard copy, not through email. So, my submission is, my lords, that they're making a issue out of a non-issue.
That is not a non-issue, Mr.
My lords,
Not an-
because our my lords, we have taken that pleading that the site did not open, my lords.
Have they accepted that?
My lords, in page 7, we have pleaded in our.
No, have they accepted?
They have, my lords, to my paragraph 9, they have not.
And this was for the grant of NOC.
Yes,
my lord. Not for renewal.
NOC, grant of NOC, grant of NOC, fresh.
Not for renewal.
No, fresh NOC,
No.
fresh NOC,
This will not.
fresh NOC.
That cannot be done.
We have complied everything, my lords, we have complied. Within time, they have.
You are required to apply online.
But they're adopting, my lords, they're adopting the my lords, they're relying on annexure, my lords, 31.
And
page
you applied, you applied offline.
We had applied online. The deficiencies were applied online.
The deficiencies were?
Deficiencies were, my lord, that time the website did not function, so therefore that was only physically given.
Where is their stand?
Their stand is, my lords, at paragraph 7 in the counter.
How much time had you been granted to comply with the deficiencies?
Within time.
14 days.
14 days within time. Yes.
But that letter is dated 26/2.
Yes.
And you have given an offline mode on 26/4.
No. The petitioner's compliance is on 13/3.
But the
13/3.
date, annexure 3, that date there.
No, 13/3 we have given. That's the admission in paragraph 7 of the counter. That's the admission of the authorities. Pursuant to the aforesaid letter, the petitioner submitted its compliances by the stipulated time.
Please come to paragraph 10.
Paragraph 10 minutes. Pertinent to mention here that in this regard, the meeting held on 23/4/2024, the minutes of the said meeting reflects that in its point number 3, which deals with the compliances and of deficiencies to hard copy, it states, as under, it was decided that the compliance made through hard copy shall not be considered as per government notification under clause 3, that no application shall be submitted manually. So also decided that hard copy is to be returned to the respective institution. It's specifically on this point, my lords, that I'm drawing your lordship's attention to annexure D1. This is that what they are relying on, that letter. This is my D2. I'm sorry, my lords, page 31, D2. D2, if your lordship.
Page 31 of what?
Page 31, the counter. Counter affidavit D2.
Counter affidavit 31.
31.
Internal 31, so.
That's annexure D2 filed by them, my lords. Your lordship may kindly, general guidelines.
31.
That is 71 of the running prayer.
Page
31,
7.
all right.
I'm sorry, my brief has not been paginated.
31 is part of your.
No.
So you want D?
D2.
D by 2.
D by 2.
Yes.
D by 2.
All right.
Dated 6/4/2020.
This is
24.
page 70.
The letter dated, I'm sorry, ma'am.
All right. Internal page 31.
Yes, D by
Ma'am.
2, 70.
Letter dated 6/4/2024.
Yes.
General guidelines for issue of NOC to different institutions for opening nursing, paramedical or allied medical science courses and the different fees / amendment thereof. After careful consideration, the government have been pleased to modify the following clauses of the guidelines issued earlier. Wide this department notification number so and so dated 22/10/2029 for issue of NOC in favor of different nursing, paramedical and allied medical science courses. Clause 3. Any organization, trust, individual, society, central government, state government, aided institutions intending to open or start an institution to impart any course, renewal of NOC must apply to the register of council online only and strictly as per the calendar of events and must have the minimum requirement. No application shall be submitted manually. This deals with, my lords, renewal NOC. Clause 5. My lords, 5. Scrutinization of application. On receipt of application, a scrutinizing team shall examine the applications and the documents enclosed. When the documents are in order, as per the requirement, a letter shall be issued by the council indicating that the institution shall be inspected for assessing feasibility for issue of NOC. In case of any deficiency, this is the part, my lords, the registrar shall inform the applicant in writing regarding such deficiencies and give a time of 2 weeks for compliance. In case of non-compliance with the stipulated time, the application shall be rejected and the applicant may apply afresh with fresh fees for the next year after floating of the advertisement. Now for, my lords, deficiency removal, it could be, my lords, because they have not had the specific stipulation that it will be online, it could be offline. And my lords, since the website did not function properly, my lord, we went and gave it. They admitted it.
Yes, where is the stipulation?
Yes, my lord.
That it should have been done online only.
Page 22, my lord, the letter issued to them of the writ petition, my lord.
Yes.
Deficiencies found in the online application for opening of new learning institutions of the academic session 24-25 to be complied within 14 days. This is the letter we are giving to all. And bottom also, my lord. Hence, you are hereby requested to submit the compliance of the above deficiency through email ID, that ID is given, within 2 weeks or 14 days of the issue of the letter for taking a further action at this end.
They are relying on the letter, communication of the government, but the government communication is silent in this regard. And they have also said thereafter that the scanned copies of the documents uploaded must be legible. Further, you are also requested to keep all other documents ready as per guidelines before inspection of the institution. Inspection may be done after compliance of the deficiency.
Have you filed any affidavit?
My lord.
Oh, this is the affidavit.
Their affidavit.
That is vendor also. So how many such applications are there?
My lord, as today's list, there are 7 matters of these 14. After 14, within 14, they have given hard copies, 4 petitions. And my lord, there are 7 cases again where they have submitted, but after the cutoff date, that is 14 days after they have submitted.
After the cutoff date, forget.
Yes, my lord.
But within the cutoff date.
Cutoff date means we are given the later, we are given 14 days within they should submit. Only 7 institutions have given within 7 days. The first 7 of these.
7 days they have given offline.
Yes, ma'am.
Not online.
No, the 7 cases, they have given offline, not in online.
But within the time fixed.
Yes, that's the time. That is in the time. But there are some cases where they have given after 14 days, they have completed.
After 14 days,
yes,
their cases you may not consider.
Yes, my lord.
But those who applied offline.
Yes, my lord.
Because they are saying that your server was not functioning.
My lord, with due respect, my lord, our servers were working. This is the plea they have taken, it's for getting relief.
Have you taken a plea that during that period your servers were working?
No, that I have not taken, but it was working because we have sent letters and we have got the response to that.
No, sometimes because of heavy load, it doesn't work.
No, for 14 days, it won't stop.
Particular date
yes,
right or the last date?
14 days, that is not there. Then that is a plea we have taken. 14 days continuously, it can't stop. Because we have to
Last date. In fact, that is why income tax also says you file earlier because there will be a rush towards the end and sometimes you cannot.
That can be taken into consideration. That is, I have nothing to say in that.
But the hard copies cannot be accepted.
Yes, ma'am.
Because they have a procedure.
Yes.
And everything is being done online.
Yes, ma'am.
So no exception can be carved out for you. Even if.
Give it to your lordship, my lord, that we have, my lords. Otherwise, my lords, but for this.
Otherwise, if you suppose someone is required to make an application online, he does not do that. And he files hard copy of to prove that the server was not working for all those 7 days. Very difficult for you to.
I would only draw sustenance from my lords what my lord Justice, Ladyship Justice Ratha said that my lords maybe probably 13th we said. 14th was probably the last date. So 13th it may be overloaded. So therefore, like it happens.
That you have not stated. That I'm just giving you the example that.
No, I have stated in my, no, I have stated due to technical defects in their website. I have stated in paragraph 7, page 7, in response to the said letter, when the petitioner tried to comply the deficiencies by submitting the required documents as per email address, but could not complete the process due to technical defects in their website.
Which
When the
date?
petitioner could, this is at
No, on which date?
13th. When the petitioner could not comply the deficiencies in the website, he immediately submitted the documents through offline mode. So this was, and they have not really denied this. That
So what
for
we
this-
propose to do is you seek instructions.
Yes, madam.
We are inclined to give them some,
Really.
but they will have to submit it again online.
Why do you want that?
Because offline will not be.
They have to give it again.
we'll again.
So such persons who submitted their applications, so compliance report offline within the prescribed date, at least they can be given a chance.
Another chance.
1 day. Only 1 day.
1 day.
All right. So if you tell this court tomorrow that you are ready, then the court can permit them to apply online. Same thing online.
Yes,
Whatever they had submitted.
Yes, madam.
No deviation from that. All those documents which have been submitted offline can be submitted online. Whether this can be done or not, you seek instructions, tomorrow we will pass.
Yes, madam.
Great.
I will.
All right.
These
Those who
7
submitted
matters.
their applications beyond the cutoff date, their cases will not be considered.
There is another batch of cases, my lord, in this case, where deficiencies were complied with. This time we had given for online inspection. The dates were given to them. They have all deferred and asked for further dates for which we couldn't do the inspection. No notice has been given. There, some of the cases, please, election was there. Some of there, some illness.
That
So
is-
that- that's the
Only
one.
this much we are going to accept,
Yes,
that those who had submitted their offline applications
yes.
within the cutoff date, their cases may be considered if they are given one chance to submit those documents online.
Yes, madam.
That is 1 day.
Yes.
So if we do it, if you have no objection, tomorrow we shall pass order. If you have
I'll read the
objection,
instruction. I'll
in
read
that
the
case also we will pass the order.
Tomorrow at 2 p.m.
Tomorrow, too.
Great.
Item number 58.
The last two items of that item 54. The reason they have given is because earlier we had filed a writ petition where we had, after, though the submission was in physical mode, offline, but we had sought for the inspection by them and we came before your lordship for a direction that they should inspect. But since that is pending, that is the reason they have given in the rejection order that the writ petition is pending. In the communication, that's what they have mentioned. But more or less, it will be covered by your lordship's direction because they have submitted within the time, 14 days time.
In the time, we will automatically will accept.
All right, tomorrow tell us.
But
And the one in the wrong email ID?
that is the item number 13.
My lord, I
That's
have
not part
verified.
of this.
I have verified the ID given by them. We have informed them for the compliance of the deficiencies, but they have complied in our that email after that 26/4 or something like that. That is what we have
After the-
given in their ID.
They are saying because they did not know you have sent it to that ID, that is why after they came.
Because the registered
That
ID is
ID
different.
That
That we
ID
have
is given by
yes.
them. That ID is given by them in their application form. Through that ID we have given.
Another batch for your lordship's consideration, I don't know. 58, if your lordship, slightly facts and 58. But in that matter, my lord, application is.
13 your lordship will take a call. Email ID.
All 54 will come
No,
tomorrow.
the item 13 which your lordship said
Yes, that will also come tomorrow.
tomorrow. All right.
Item number 58 also.
As your lord, separately or tagged up
So
together?
13.
13,
There are
1,
two.
3.
So
There are
your
two
case is
matters.
also similar to what
It's saying
was being
slightly
argued,
different.
that you submitted your,
No, this case is, the 13 is little different, as my Lord Justice Raj said, because since on the date when we were supposed to make the application, there was glitch in the website. It was not accepting from the registered mail ID. So we had to send it through another ID. So, but their registered ID, while they sent us the deficiency list, they sent it in the new ID, not in the registered ID. So that was why they delay. But we have submitted the documents, but that is at a delay. That is admitted, my lord. Tomorrow.
I think you showed us whether the actual compliance was before the last date. You might have communicated afterwards, but the actual compliance, whether it
No.
is the next date.
Compliance were all were documentary, all were document like lease deeds and those, because these are for renewals, not for the fresh.
Okay.
So renewal mean everything was on record.
Okay.
But
Okay.
there is nothing new which was to be added.
So everything was in existence.
It was in existence.
My lord, in the item number 54, there are some matters where we have allowed them. They wanted for inspection. We have inspected that. That is become that I pay. That is page 34, my lord, cause list. That item number, that is 13931 of 24. Katie School of Pharmacy, my lord, that we have inspected the institution. As the prayer was for inspection, we have gone for that. And then the 13837, Katie School of Nursing, he has applied for change of, we have said we cannot change the institution's name. So he has to apply in afresh, we have informed. He has to apply afresh for NOC for the next year. And the item number, that is 14028 of 24, next one, we have already issued NOC to this institution.
yes. So this application has become infructuous?
Yes, ma'am.
028
Yes, and
and
the previous one.
13934 also has become infructuous.
Yes, ma'am.
934. 13931 or 934?
13931, 13837.
That is slightly different. Change of institution.
Which one, ma'am? Katie School of Pharmacy,
Change of
ma'am.
name. Change of name. So that you have complied. Is that also infructuous?
No, that has, we have already said that you should apply for appraise for the next year. Because,
Two applications have become infructuous,
Yes.
we are disposing them.
yes, ma'am.
CWJC number 13931 of 2034. The petitioner.
My lord, in case of writ petition 13837 of 24 and writ petition 13931 of 24, on behalf of Learned Counsel Sri Om Swarup, the opposite party had to file counter affidavit and they haven't done yet. My senior.
Your prayer was for inspection, that has been done. 13931.
Yes, my lord.
I have informed the council.
They have conducted the inspection.
Yes, my lord.
So this has become infructuous. You sought for inspection, that has been done.
Yes, my
To
lord.
DMET to cause inspection of the college for the purpose of grant of NOC. So it is a stand on behalf of the DMET that the college has been inspected. So in such view of the matter, the application has become infructuous. Next. WPC number 14028 of 2024. This application has been filed for the matter. The dispute relates to grant of NOC for running BSc nursing course. So it has been stated by the counsel for the DMET that NOC has already granted in favor of the institute. So this application stands disposed of as having become infructuous accordingly.
That is not the only prayer in that writ petition.
Yes, only there was.
No.
Which one?
Other prayers are there. So if consequently those are also allowed, then it has become infructuous because the prayers are to grant no objection certificate for participating in the OJ Pharmacy Counseling for 2024-25 and again OJC Pharmacy Counseling, I think, repeated that same prayer. But the third prayer is to inspect the petitioner college and grant affiliation for the academic year 2024.
That is, we cannot, that is the affiliation is to given by the.
Then how has it become infructuous?
Then it should stay.
It will be taken up tomorrow. Please ask your senior to be there.
Yes, madam.
May I please? There's another batch.
Mr. Jenna, is he there, Mr. Jenna?
Item number 58.
58, not the first item. The only issue before a lordship, Lord, here it's a case of nursing, here's a case of new institution, here's a case of application of no objection in time, and the compliance was done. Lord, only one issue remains, Lord, that according to them, I do not have the fire safety. Lord, fire safety is very important, but it's more important is that a fire safety is not required for an institution of my nature. Your lordship kindly turn to page 33. Page 33, sir. Your lordship get it, page 33. And just little later I'll place to your lordships. This is what I had applied for and what the competent authority wrote to me in the fire department. Have you also got page 33, sir?
Yes, annexure.
Sir, annexure, page 33.
Go to second go.
Annexure 5 series, sir. It's a part of 5 series at page 33, sir.
33.
Of the writ petition.
Yes.
May I just place that note? With reference to the, this is my institution, Lord. With the reference to the subject cited above, it is to intimate that as per of the OFF and FS rules 2017 and OFS rules and rules 2019, the following classes of educational buildings are likely to have risk of fire and shall have at times have a valid fire safety certificate. But they say the educational buildings having a height of 12 meters, having a built-up area of 1,000 square meters, having 3-storied building. Whereas, this is important, the aforesaid building was inspected on 15.3 and its structural parameters that doesn't meet the above mentioned criteria. The building height is less than 12 meters quarters, less than 3-story building, and total is less than 1,000. That means I'm below that, as per the rules not required. In view of the above, as per the Odisha Fire Private, etc., the aforesaid building, etc., does not come under the classes of education building which requires a fire safety certificate. However, you are required to do, not as everybody has to do, including me and every house, and you have to take measures, but no certificate is required because certificate has an elaborate procedure. Certificate is not required, but a ground on which they have rejected is you do not have not furnished the certificate. That's the only ground. Kindly see, sir. Kindly see, sir.
Have they filed affidavit?
They have filed an affidavit, yes. At page 50. They say 2 reasons. A, I do not have that fire certificate, which is not required. They say that this letter was communicated 5 days after the cutoff date. This cutoff date, I'm sorry to say so, this cutoff date is there. But there is also your lordship's order that in appropriate cases time can be granted. Your lordships have also passed in that order, in para 26. What your lordships have rightly said, the last date of admission, in fact, the examination of this has not been held. It will be held in September. The last date as fixed now is 30th of September. As fixed now. Last year they had extended to 30th of November by the All India Council. These are very sacrosanct dates. Procedure is also important, but not that it cannot have any leeway to accommodate genuine cases.
It should not have any.
So,
We have to strictly follow.
Strictly followed. subject to your lordship's,
Subject to leave.
subject to leave. Yes, that's the
have
reason
to-
I'm saying that I have applied.
They have to seek leave.
No, if they do not seek leave, I should not suffer, my lord. This is your lordship says, fire safety, your lordship says.
You may convince them that they should seek leave.
Lord,
No, are you saying that it was rejected because you didn't comply with the fire
yes,
safety?
yes, 50. Kindly see, Lord, 50.
That you don't require.
50, sir. Sir, kindly see 50. Page 50. Fire safety. This is
See,
my lord.
you required a fire safety certificate.
Yes, ma'am.
Which could not be given, which was not, which the fire safety department itself has declined to give.
Not required under the rules. That's what we say.
But that has not been given at the time when they have given the application. That was not been given to us.
No, exactly.
All right, let us see your provision.
Yes.
That fire safety certificate is required. Where is that? Where is that? What is the nature?
Yes, ma'am.
What is the nature of certificate you require for fire safety?
That is in Form B. Tomorrow I will
Form
apply.
B,
sir.
It must be here in some document.
Yes, ma'am.
I've got that Form 5. I've got the rules.
What is that? What is there?
Yes.
What is there? Please tell us.
May, sir. Form 5 is there. Form 5 is part of the rules which required a certificate wherever it's applicable.
What is that?
Sir.
Let's see the language.
One page about it.
You said document as per requirement not submitted. So what is
Form
the
five.
requirement?
Higher certificate only. That we have.
You will
not-
have to reconsider.
Yes, ma'am.
Yes. This is the Form 5, sir, under the rules. And that is the Form 5. And the Form 5 is under the Rule 13(3) of the rules. Rule 13(3). I've got the rules, sir. Thank you.
Your form is not required to give.
But they have applied to the government of Orissa for safety,
No,
higher
you-
safety certificate.
You asked to apply, we
They
applied.
applied.
Yes.
We applied. They said that not required. sir. 13(3) Bethel.
See, you were asking them to do something
Yes,
which was impossible.
I could understand.
Your
When the
requirement
building
should
doesn't
be
want to get given.
fire safety certificate or certificate saying that it is not required. If it is not there, then there is no deficiency.
Seek instruction on this.
Yes, ma'am. Tomorrow.
Tomorrow to PM.
Grateful, sir.
File it on here.
Same, sir.
The same case, same item,
Along with that, 2K matter. Grateful.
File it.
in the same item, my writ application is 16423 of 2024, my lord.
This is regarding
Mr. Padhi, please
Regarding renewal of
give
NOC.
these- give these tomorrow.
He cannot, hard copy was not, was denied, therefore 4 days or 5 days was delayed to file online. My lord, in 2022, NOC is granted, 2023, NOC is granted.
you are taking up such matters, Mr.
But when?
All- Tomorrow,
When
we
you
will take up
fix
these
one-
matters. All such matters where the compliance affidavits, compliance reports have been filed offline. Those matters we will take up tomorrow.
And here is a case of renewal, my lord, renewal of NOC, my lord.
A renewal.
And my lord, there is no deficiency. My lord, my humble submission would be, my lord, a good of cases have been done within these 3-4 years. There is oblique purposes they are giving it, my
Your
lord.
experience is.
We had given it 2022, my lord. We had given it 2023 also, my
All
lord.
right, all right,
Same document they are saying deficiency. Without due application of mine.
all right, tomorrow.
Your Lordship, the fifth matter, I think, can be disposed of because it is covered by yesterday's order, Your Lordships. 16309 of 2024. Fifth matter in serial number 58. Of course, the order has not been uploaded, but we have yesterday's order has not been uploaded, which Your Lordships have given leave and also disposed of Mr. Mishra's matter. It's covered by the same order.
WPC
My lord,
16309, Shanti.
My lord, that is the order covered by WPC number 16986 of 24. Yesterday this case.
That which you have said that.
Yes,
Yes.
You are considering. So
Yes,
that
yes.
is also necessary.
Yes.
It disposed
That
of.
is,
On counsel appearing on behalf of the parties have submitted that the writ petition is squarely covered by this court's order dated
29.
yesterday's order.
Yes, madam, 29.
Passed in WPC number
16986.
986 of 2024.
Yes, madam.
Stop. This 24. As the said order takes care of the grievance of this petitioner also. So this application stands disposed of accordingly. Yes.
Therefore, there are other two matters that I also have in the list, but I think Mr. Manti will have objection. I think one of them is they did give us for online inspection, but it was during the summer vacation. That was the only issue, and we did seek for time. So had they accommodated us, so it was a summer vacation.
That is what he said. There are a number of cases
Yes.
where they've asked for time.
Yes.
Because it was genuinely a summer vacation, so that's the only reason. And another matter is, of course, of that difficulty of the email ID. So
we will
that-
consider rest of the matters.
Lordships.
And one matter in disposed of, my lord. 58, in item 58, 15677 of 24, that is covered by the earlier decision in WPC number 39868. That was disposed on 14/5/2024.
39.
39, WPC number 39868 of 23. Disposed upon 14/5/24. They were admission, they have granted NOC late because we could not take admission.
My lord, that admission matter which my lord didn't allow admission after the cutoff date. That is covered by that. They cannot admit
It
students.
is a private dismissal.
Yes, madam.
Covered by that.
14/5, the admissions.
So it will be dismissed.
Yes.
Learned counsel appearing on behalf of the parties agree that this petition may be dismissed in the light of this court decision rendered in WPC number 39868 of 2023.
23.
Passed on 14/5/2024.
Yes, madam.
Which is this matter?
No. Vet Notice School of Nursing.
Yes, better notice.
Veterinary School of Us. WPC number 15677.
15677 of 2024. All right.
Item number 36.
May I be permitted to submit the counter affidavit? I am filing it in course of the day and giving a copy to the other side. Let it come next week. A counter affidavit has to be filed in this case, my lord. I have got it prepared. I'll be giving a copy to the other side and let it come on the.
Well, as I received, I'm for the petitioner. I received the copy.
You are for?
The petitioner.
Here, he is there.
He already received the copy.
You want to file reply?
Madam,
Already filed.
already filed, but that is not at it. I will be filing today.
All right. It
I
is
cannot
stated
file.
by learned counsel for the petitioner that the joinder affidavit has been filed to the counter affidavit filed on behalf of the respondent. A copy of which has been handed over to learned counsel for the respondent today itself. So from
Well, as to the
this says the joinder affidavit is not there on record. Not there on record. So
You file a rejoinder.
No, I am filing the counter. If they want to file the agenda,
Who are
they
you?
No, but counter, writ appeal, what counter?
Who are you?
I am the respondent, my lord.
From this respondent.
My lord.
And who is the appellant? Just a minute. Who is the appellant?
I'm the appellant.
You are the appellant. What is your case?
My lords,
Why
actually,
any affidavit should be filed in this case?
my lords, actually, I'm appearing on behalf of Satyasmurthy Mohanty.
All right.
So I received instruction that they will be filing the counter and
Why are you allowing them to file counter? Why counter? Sir?
Just the grounds I want to meet, therefore I have filed the counter.
You want to?
Meet the grounds they have taken in the writ appeal. For that I needed to file a counter.
So what do you want?
Very short counter, only a short issue.
my lords, we'll take instructions after perusal of the counter. If at all necessary, we'll might.
You're not required to take. You have to place your case on the basis of the grounds which you have taken.
Very well, my lords may keep it to any other date.
As requested on behalf of the appellant. You are the appellant.
Yes, my lords.
Does this matter on 1 week? 2 weeks, 3 weeks.
Item 37.
You're Mr. Mohanty.
I'm appearing on behalf of Mr. Mohanty.
What is your name?
S.S. Pradhan.
Item 37.
Much obliged, my lord.
Please, lords. Sir, we'll seek 2 weeks time to file rejoinder affidavit. It's a PIL matter.
Yeah.
Lordship. Adivasi people are affected parties. Lordship allowed
That
2 weeks
road.
time.
That road.
Road. Realignment without authority.
In this case, I am entering appearance, finding intervention application for the private landowner over which the petitioners are claiming rights under the Forest Rights Act 2006. My citizen land, they have enclosed. The subject matter of the land is also in the civil suit. Civil suit, we got the decree. Eviction order passed. Police force deployment direction was given. Still these Adivasi people in the name of Adivasi, they are occupied and enclosed the government land. Slowly, gradually, they have also occupied and enclosed our land. Over this land, my lord, the proposed road is proceed.
I'll file
the
response.
petitioners are not real Adivasi, only 50 to 60% are there. Some land grabbers and mafias are behind their back. They are coming this PIA. Because this matter was yesterday in the list and last week also on Thursday it was released. I could not find in the court itself, my lord, the intervention application. I have sought the copy, my lord. Today. File in the registry.
I'll file response to
We'll take it up.
I have sought the copy. My
Register for the.
Because it has to be numbered.
this case, my lord, actually, I have given all the documents, my lord, this Kitiban land. And it is also homestead land. There are about 7 acres. The few government lands are there. They were occupied. And slowly, gradually, they occupied our private land also. They are not allowing us also. Several prohibitory order also against them passed. Police report are there. These people are rowdy people and always in drunken condition. They did not allow us to enter our land also. Now they are on the plea of obstruction of this road. Either this way or left side or right side, which way the road will go. What is there, well, what is there?
No, if they're staying there, they have some objection.
Well, they are claiming the jungle rights. If there is no jungle kism land, you are occupied the government land unauthorizedly.
But was it ever recorded as jungle?
No. If there is no jungle.
No, not question of no jungle. Recorded as jungle, but no jungle, and no not recorded as jungle, there's a difference.
But that aspect also I have explained, my lord, your lordship, our 1927 Indian Forest Act said 3 kind of jungle. Protected forest, reserve forest, declared forest. Orissa Forest Act 1972 also 3 category of forest. Thereafter Forest Conservation Act 1982. In T.N. Godavari case, Supreme Court said, my lord, in the PIL matter, that while there is a forest growth is there, then the district level committee will be constituted in each state
and they will verify, and the report shall be prepared, and the appropriate authority will declare. Till then, there is not a. And I have also.
So whether you had the information about the suit?
What?
No, we are asking Mr. Mansingh.
Had the idea about the suit which is pending according to him?
Sir, I could not follow, sir.
What he is stating, the civil suit is pending and there are
I have no idea.
prohibitory orders and all
I'll
that.
file response to the intervention application. I have no idea.
Petitioner number and other
I have no
signatures
idea.
are all. So
No, maybe, but
I'll file response.
they were different
If-
in my suit.
if he is not the counsel, he may not know. Petitioners may know.
I'll file response. I will get it clarified and I will file response to the intervention application.
Because if any
We will
observation would be passed by this honorable court, it
File
will
it.
ultimately affect to our.
File it in the list. An intervention application is intended to be filed on behalf of certain persons who claim to be the landowner of the land which is subject matter of the present or its petition. Let it be done. Let a copy of the intervention application be served upon learned counsel for the petitioner
and states. I have
from a BDA and let copies be served upon learned counsel for the petitioner, learned counsel for the BDA and learned counsel for the learned AGA for the estate. So stop this matter on 2 weeks. Let the intervention application be filed by tomorrow.
Today itself.
As you wish.
It is ready.
No, if
Today
we say tomorrow, you can still file today.
From 38.
Okay.
Obliged.
What is that? May I pray? Your lordship, it will be easier for your lordship if the state council produce the map.
You will hear the cases. You'll hear the cases. Let us see what happens that day.
May I please, madam? My lord, I have filed an application for addition of parties. My lord, I have filed an application for addition of party, that is Department of Steel and Mines, Government of Orissa. And it is a necessary party, my lord, because I'm challenging the, my lord, the indiscriminate lifting of sand from 2 sand sirens because they are not being put to auction, my lord. Hence, and since the sand sirens are under the jurisdiction of Department of Steel and Mines, my lord, they are a necessary party. I filed an application for addition of party for that, my lord.
So it's a PIL.
It's a PIL.
Twofold prayer to stop illegal mining and to auction those.
Auction
sources.
the sand sirens. So
Your Lordship, we've already filed a counter affidavit in this matter. The Department of Steel and Mines were already implicated. They were informed, Your Lordship. They had given the power to the collector of Kendrapada to file the counter affidavit also on their behalf. There has been an inquiry also done by the Tahsildar, Patamunde, and the mining officer, Your Lordship. B/4 is the inquiry report, Your Lordship. They have reported that there has that a mining officer complaint in the shore of River Brahmani for detailed inquiry about the matter dated 28/6/2024. In the alleged area, there is an earth and stone embankment. In the time of inspection, there is no any vehicle or.
Affidavit is not there on record. You filed your affidavit.
Yes, Your Lordship, we filed an
When
affidavit.
did you file?
You filed it yesterday, my lord.
We filed on 23rd, Your Lordship.
No, I received the
23rd.
copy yesterday. I'm extremely sorry. I received the copy yesterday. They must have filed.
On 23rd.
Whole week has gone. That also I told you. Refiling it is on immediately. Oh, since Steel and Mines is not a party, that is why you brought instructions, but
Yes.
on the record they are not a.
On the record, they are not a party.
The Revenue Disaster Management is a party.
But that is not so material in such cases.
That has to come on record.
8877 of 2024 has been filed. This application has been filed for impeachment of the Steel and Mines Department, Government of Orissa. Its secretary has opposite party. Number
Right, my
5. So considering the nature of the relief sought for in the present writ application and other facts and circumstances, this application is allowed. So and so, let so and so be treated as opposite party number 5. So stop. What do you call it? Consolidated copy.
Consolidated cost title.
Consolidated cost title be filed on behalf of the petitioner by tomorrow. By tomorrow. So stop. It has been next. It has further been stated by learned AGA appearing on behalf of the estate that a counter affidavit has been filed on
23rd of July.
E5.
Third.
E5.
E5.
3rd of July 2024. 3rd of July 2024, which is not there on record. Stop. It is not known as to why the pleadings being filed online are not being placed on record. So stop. Let the Registrar General submit a report as to why the petitions, pleadings, any pleadings, documents which are filed in the registry online are not being placed in the e-brief of the court, taking up e-brief of the paperless courts. Okay.
Lordship, I'm filing the hard copy here in court.
Do it.
Item 39.
Ma'am, please, your lords. Lord, it is a blacklisting matter, ma'am. The blacklisting order was passed on the ground that the petitioner not achieve milestone on imaginary grounds and as the OPWD code.
Where is the order?
Lord, the code provides me, Lord. Sorry, your lordships.
Where is the order?
Yeah, Annexure 1, page 23. And the code provides and must be defective work as pointed out. There is a conjunction and only one part has been, they have alleged, your lordships. Your lordship, Annexure 1, page 23. Ma'am. Your lordship, may I permit you to place it?
What is the leading case on blacklisting?
Blacklisting, my lord, that erosion equipment, that judgment, my lord, your lordship, that the fair opportunity of hearing.
Which case?
That is lordship. That is a still golden, my lord, judgment regarding
Golden.
erosion equipments, chemicals, and state of West Bengal, your lordship, 75 Supreme Court, my lord. The steel hold good field, my lord. And here is, my lord, the PWD, this guideline was blacklisting was passed under the PWD contractor registration rule, which is executive instruction. Here rules provides guidelines. There are, my lord, if your lordship, one case of that guideline, this is a very small guideline. But this stipulates their constant non-achievement, page 166, my lord.
All right, tell us,
your lordships,
whether in the absence of any guideline, blacklisting order can be passed or not.
Yes, your lordship, Pulja Industry say that, my lord, but reasonable, proportionate that in case of that circumstances, my lord, that
so the blacklisting order can be passed.
Passed, my lord, in absence of if tender condition permits, or my lord, there is no
question of tender. If there is nothing, even then the blacklisting order can be passed or not. And therefore, we wanted to know from you what is the leading, which is the leading case?
That is regarding that, your lordship, that regarding when there is absence of any guideline and specification, whether the blacklisting can permissible or not, your lordships. That regarding that judgment I have not with us at present, my lord. But some case he has saying that this, if there is no condition, you can't blacklist because there is other remedial compensation. Suppose it is violates, you can giving a compensation you can't imagine, or you can't blacklist, my lord.
That is one aspect where there is no guideline, but whether you can do blacklisting. You have said that some decisions say that you cannot blacklist, but other
Remedial is
remedies, not remedies, other things they can do.
Is-
But whether they can blacklist or not, I'm sure you have it. That I think you have done a lot of research on this.
I have to check up that specific
You
question.
may not have brought the decision, but
I am not specifically, my lord.
Have you examined Kulja?
Yes, your lordship. Kulja is
Kulja Industries?
yes, yes, lordship, that where it provides
BSNL?
yes, lordship. That your lordship. That
So there was no guideline.
Kulja say paragraph 25, your lordships.
Was there any guideline in that case for blacklisting?
Yes, lordship, paragraph 22.
What?
Of Kulja, my lord. Kulja judgment, my lord.
Was there any guideline in that case? Guideline has been laid down by that case. In that case, whether there was any guideline laid down by the employer that in such circumstance you shall be blacklisted. There was none.
Yes,
That is the leading case.
yes, Kulja.
That is the first case.
Regarding absence of that, my lord, your lordship. Kulja make a development, oral hearing, opportunity of oral hearing is required. His development, my lord, that part.
This oral hearing is not required, only principles of natural justice is required to be followed.
and depending on the gravity, the period.
Exactly.
Period. And what is the final result? Just see in that case.
His lordship.
ठीक है भाई.
But the period, my lord, regarding the regarding period of proportionate of the blacklisting.
Everything, the Supreme Court did nothing except for
Fixing the period.
fixing the period.
Thereafter, my lord,
Thereafter what? Thereafter blacklisting, see, this is mainly based on the principle that the employer is the best person to decide
his lordship.
whose work he will be taking. Like if you have to get some work done, then I may ask that no, I'll not take your work because of so many things. Because your appearance is not good, because you don't perform well. So many things.
Yes, sir.
The employer is the best person. But when it comes to the estate as employer,
Yes.
then there are certain restrictions. But again, that cannot take the basic character of that state as the employer. Again, the state has to keep in mind the quality of work, your capacity to work, and then it may take that when you discharge your duty, the employer may consider that you are not performing well. Well, so in future also, I will not take any work from it. And that is the blacklist. If some prescription is there that these are the grounds on which you can be blacklisted, there can be third ground also. There can be fourth ground also. Like you are the contractor, you are performing the things well, but somehow or the other you fall into some such serious scandal that the employer wants that no, taking work from you shall unnecessarily dampen the image of the organization. So
Yes.
There's so many, can be so many circumstances. You cannot confine to that. You can make out that the only effect of the serious effect of blacklisting is that other employers also refuse to take your service.
Exactly. The civil death, my lord, you lots of the company, my lord, that he cannot put other bidders, stigma, other things, my lord. So this is the one. Here is the state. There is a guideline for provides blacklisting. My lord. There is a guideline, executive instruction to blacklisting the PWD contractors who are operating on the corporations, my lord, different department of the government of Odisha. There are 6 elements to component to be blacklisting. That is, I have annexed that guideline on similar page 166, lordship. That chief engineer department of blacklist the contractor with the approval of the concerned administrative department on the
item number
39.
that guideline, your lordship, page 166.
One 166.
Your lordship, this is the codal provision for blacklisting of the contractor. Under this codal provision, I was blacklisted, my lord. Lordship, on page 166, your lordship.
Yes.
Your lordship, can you the chief engineer of department may blacklist a contractor with the approval of concerned administrative department on the following grounds, my lord. A, my lord, misbehavior threatening department supervisor during execution of work. B, involvement in any sort of tender fishing, which is not allowed. C is, my lord, is the, my lord, present case, your lordships. Constant non-achievement of milestones on sufficient and imaginary grounds, my lord, and your lordship, that I am, and non-adherence to quality specification despite being pointed out, my lord. My lord, this is the, my lord, to be joint violation must be have been.
You are reading.
C, my lord, AC, appendix 34, C, your lordship, C. Page 160, serial number C, your lordships.
No, it is not that there to be both two non-compliance should coexist for exercise of that power. See, these are A, B, C. They could have said D, that imaginary ground.
Exactly. Your lordship is correct. But C, my lord, I am on C, my lord.
Non-adherence to quality specification.
Exactly. C is, my lord, I am on, yes, first misbehavior, that is a one part. A can be blacklisted, B can be blacklisted.
That is the ground, then you
C can blacklist. C is, my lord, C, your lordship, can you see? Where C is 2 parts.
Yes. C is 2 parts, and on either of the 2 grounds mentioned in C, one can be blacklisted.
No, or what? There is no word of or.
All right. We are reading a guideline, and even if it had been in some statute, we could have interpreted it. Very clear.
Your lordship, kindly see. Constant non-achievement, my lord, I may permit again, my lord, subject to your lordship kind permission. Non-achievement of milestone on insufficient and imaginary grounds. My lord, I am full stop, my lord, I am pause a moment for that. That grounds in the contract provides, if not achieving the milestone, I am liable for penalty, my lord, damages, my lord.
If we accept your contention, then if a contractor does not adhere to the quality specification, despite being pointed out,
yes,
but it had constantly achieved the milestone,
then I will accept, my lord, your lordship. Your lordship on this side, that, and your lordship, that I will check. That your lordship is, I mean, first your lordship is saying if second complied, first is not complied. My lord, I will check. Lordship,
what will you see?
Your lordship is. Your lordship, see.
There is nothing.
No, my lord, there is, here is, my lord.
Your affidavit, we will see. Have you filed?
No, my lord, I have not filed.
Filed your
My lord. Okay.
8 weeks time is allowed for the state to file counter affidavit.
Item 40.
In item 40, I'm finding the counter affidavit today for the opposite party one.
I appear for the petitioner in this matter. May I just please? I have filed an IA, which is a flag B. I will press that application today because unless I am protected, this writ petition is going to turn infructuous. Notice was issued by your lordships on 15/4/20. Yes, flag B.
IA flag B copy has not.
So what is this matter about?
This is a tender matter, Opposite party number 2, despite not having the essential prerequisite criteria, his bid was technically first accepted. Thereafter, his price bid was opened and he was adjudged to be the L1 bidder. That is what I have challenged before your lordships. Your lordships may just have the notice inviting tender at page 23. If your lordships have, I will just take 1 minute's time. At page 23.
Annexure?
This is annexure 1. 22 it starts. 23. Your lordships have it now. Annexure 1 minutes.
Page, please.
Page 22, it starts 23 minutes.
Yes.
Annexure 1 starts at page 22 and I'm referring to page 23, which is the notice inviting tender NIT. The lordships have it.
No.
It's dated 5th of October 23 and the
page
23 I'm reading page 23.
Yeah.
Its subject is cleaning of overhead water tanks of residential and non-residential building and underground reservoir in Nalkonagar Township and CISF colony by mechanical means. This is the work which has been tendered for by opposite party number 1. Your lordships can straight have page 71, which is the essential pre-qualification criterion.
$71.
Yes, ma'am. It's part of the same annexure.
Just
I'm sorry.
98.
71.
71.
Yes. Your lordships have it?
Yes.
Yes. The subject has been stated, which I have just read over to your lordships. Thereafter, agencies intending to participate shall fulfill the following minimum pre-qualification criteria with supporting documents, and they need to fill up Annexure C25 and C27 of the NIT to ensure submission of all documents as per the pre-requirement of NALCO.
Sorry.
Criteria.
As per requirement of NALCO, not pre-requirement.
I'm very sorry. As per requirement of NALCO. Pre-qualifying criteria means technical. The bidder should have experience of having successfully completed similar work during the last 7 years ending on the last day of the month previous to the one in which NITs are invited should be either of the following, Malaj. Malaj, 1, 2 pertains to 3 works of a particular quantity, particular amount. Second one is of a particular amount, 2 of them. 3 is important. 1 similar completed stroke partially completed work with above criteria having executed value not less than 17.36 lakhs. And it has been said, Malaj. Similar work, Malaj, at the bottom your lordships will find has been defined. Similar work means, your lordships have it, Malaj. It's in bold. Yes. Similar work means cleaning of overhead tank, underground reservoir by mechanical means. Well, this is what is the definition of similar work. Now, there were a total of 5 bidders, Malaj. 3 got disqualified. 2 of them, myself, the petitioner, and opposite party number 2 have been qualified in the pre-technical round. Opposite party number 2, Malaj, has with regard to this pre-qualification criteria has submitted a work order which your lordships will find at Annexure 5, page 234. 234, your lordships, ma'am.
Yes.
This is what is the document which has been submitted by opposite party number 2 and has been accepted. This is a work order. Malaj, your lordships will find at the top, National Aluminium Company Limited. The date is 21/12/2019. Malaj, your lordships have the subject.
Yes.
Subject is maintenance of wastewater treatment plant, sewage pump house for the year 2020-2022. This is not even close to cleaning of underground reservoirs and water tank. And this has been accepted by opposite party number 1. And he has today been given a work order. They are filing my counter, Malaj. I don't have a problem to that. But your lordships had issued notice in this matter. I need to be protected in the meanwhile is all that I'm saying.
The IA my learned friend is pressing, that is at flag B. Copy has not been served in that IA. Only one IA was filed earlier along with the writ petition, and I have received copy of that. And I'm filing the counter today. So far, the second IA that I have not received.
The second,
I am not aware of the prayer in that IA.
The first IA, the prayer for staying the tender process.
Yes, and
So now the tender process has proceeded. You are granted work order.
Work
the work order has been
since
That
and the
consequent to
work
that.
is going on since 2nd May. That work order also I am filing today in the counter affidavit. Because
No, but you will have to pay the thing. Your pay from your profits. If he finally succeeds,
Lordship,
then
if
you will have to pay that.
if the petition finally allowed, then the work order will be set.
You are for the party who's got the contract on Alco?
No, I am for Nalco. Opposite party 1. I have awarded the
The other
contract.
side. So you-
Malaj,
Opposite
party number 2 has been served. Malaj. And also with regard to this IA,
No, he is not.
he has not entered a
No one has appeared, it seems. I am not aware of the if notice is sufficient or not. That I am not aware.
There you are doing your work.
Yes, that so far as whether he has appeared or not.
What is your explanation? So many facts.
So far as the similar work is concerned, Your Lordship, the work order which my learned friend was pressing, in the scope of work, is cleaning of underground reservoir is also there. That was also part of the work.
Underground reservoir and wastewater, I think there's a difference.
Yes. No, here in this work order, which my learned friend was placing reliance on, if your lordship may see page 240, they're part of the same work order. Because we had issued the earlier work order.
Okay, okay. 240, what is it?
Page 240, because there's a detailed scope of work, the same mechanism process of cleaning underground reservoir was involved in this work order also.
Where is that?
That is page 240.
Page 240, yes.
Activities number 23.
So have you filed affidavit?
I'm filing today, Lordship.
So file it, we will just.
Lordship.
Mr. Mishra, one interesting thing. Similar work, this is a work for mechanized process, sorry, manual. And similar work you have given mechanical process.
No, here also the work order which he had given.
No, not that. In your tender, you have described the similar work.
In that, the mechanism also it is involved. Is
No,
it
no,
there?
it's a wastewater treatment plant,
This is the work order. Where the tender they're explaining what is similar. work.
mechanical.
Where mechanical means?
Define what is mechanical. What is similar? What is similar? Manual, sorry, manual. No, it says manual.
Tender is for manual.
Tender is for manual.
Similar, they say is mechanical. That's
Similar in this is mechanical.
Yes. So whether that includes, I don't know, but he's not challenging at that aspect. He's saying this is wastewater, not the
Well,
other
it's-
water.
The reliance which is being placed by my learned friend Malaj at page 240, item 23, your lordship may just read with me what it says.
No, let us see again that notice, relevant part.
Malaj, that is at page 71, Malaj.
Typing down.
Similar work.
No, but this is how it defines, accept the definition.
Mr. Tripathi, the work
Yes.
order has been given since May. Why
Malaj,
you press
I
it
will
first?
explain to your lordships, Malaj. I had challenged this, Malaj, and your lordships had issued notice.
No, that is all.
Yes,
That is all right. We'll
Yes.
decide the matter.
Yes,
But why a stay order at this when it is already
Point
3 months have gone? Had you come immediately, we could have understood.
Malaj, I had come in fact immediately. I came before your lordships on the 3rd of April. Malaj.
We cannot grant stay.
Talking about
Because
stay.
the work order has been given,
Yes.
he is working. It's a
Yes.
different matter how finally we will adjudicate upon about your compensation, his rights, the other side is not appearing. So many things.
Malaj, may I just then pray? Let Malaj, the work order which has been passed be subject to the outcome of the writ petition, is what I will say.
That will be good.
And if your lordships can have a
Counter
date for
affidavit
final hearing.
has been filed. Has been filed or going to be
Today
filed?
I'm filing.
File it in the
I'm
registry.
filing the registry.
That counter affidavit on behalf of what's the party number?
1.
Will be filed by tomorrow. So let's this case on 2 weeks. So in the meanwhile, and counsel for the petition shall be at liberty to file rejoinder to the said counter affidavit. So notices have been served on the other side.
Yes, yes. Notices have been served.
Despite valid service of notice, the opposite party number, who is he?
2.
2 has not entered appearance. So stop. Let a copy of the writ petition be handed over to and counsel for let copies of the pleadings be served upon opposite party number 2, who is said to have been given the work order and he is working accordingly, he or it's a company.
It's a company.
And it is working accordingly under NALCO, through any official of NALCO. Copy. Full stop. And a short affidavit will be required to be filed as regards service of the writ petition, service of copies of the writ petitions upon the upon the representatives of opposite party number 2 from opposite party number 2 shall do it.
Your lordships can say that Millard's action shall be
It goes
subject.
without saying that the impugned action shall be subject to final adjudication of the present writ application.
Your lordships are fixing a date.
Yes, 2 weeks.
Great, great.
Item 41. Okay.
My Lord, I am on behalf of Learned Counsel Sri Om Swarup seeking adjournment.
There is no representation in behalf of.
My Lord, I'm for the petitioner on behalf of Learned Counsel Sri Om Swarup. We were to find rejoinder in this case, my Lord. I'm seeking adjournment. As sir is suffering from viral fever and could not appear before this honorable court. The court may kindly be pleased to put this matter in some other date, my Lord.
4 weeks time is allowed for the petitioner to file a rejoinder affidavit to the counter affidavit filed on behalf of the petitioner. Yes.
Obliged.
Item 42.
May I please, your lords? Well, in item 42, I have challenged the rule 4 of the repeal rule, my lord. Well, rule 4 of the repeal rule, my lord, 22 repeal rule. A similar matter, lordship have kept to tomorrow, my lord, 2 p.m.
One number if you give, we can tag it. Do you have any number?
I'll give my.
Item 43. 43.
And the petitioner, who is a student of a ITI college, my lord, he prayed for his institution name may be displayed in the state scholarship portal, for which he will get the stipend for prosecuting studies, though he is a ST student. The fact is that according to the government of Orissa selection process, the petitioner has admitted in the Matrimonial ITI college to prosecute his study as a ITI in the concerned school. That is
this PIL.
No PIL, my lord.
Eh?
This is the education institution for getting the scholarship. Though he is a ST student, after getting the stipend, he can prosecute the study of the ITI. Otherwise, he cannot continue the study.
What is your problem?
The fact that the opposite parties have not displayed the name of the institute in the state scholarship portal, for which the petitioner has not.
Which institute?
My lord?
Name of which institute has not been uploaded?
The petition institute, along with the other connected matters, 6 institutes, all the petitioners are the students of the concerned colleges, my lord. The fact is that after the admitted in the IT school, IT colleges, my lord.
All right, tell us frankly,
my lord,
whether you have been engaged by the students or the college.
I'm on behalf of the student, the petition.
You are appearing on behalf of the
student, my lord, which continue.
But whether you have been engaged by the students or the college.
My lord.
Let us be clear.
The student who is continuing the study, but due to non getting the scholarship, cannot continue study, and he cannot fill up his form fill up. The form fill up will continue, will start from tomorrow. It will on that from 31st July to 8th August.
But you are only one student.
No, for this institute, one student. And for another 5 to 6 institute, or 1 or 2 students like that.
So you copied and pasted it, that is why petitioners. All right.
The government of India has sanctioned scholarships for SC/ST students to continue their study in the technical colleges and schools. Therefore, the state government.
What is the system here?
Well, I have filed a counter, my lord. You also can see that counter. There is a system that, as per the Government of India guideline, the state had to verify physically the institution, and as per the report submitted by the inspection officer, if that institution is eligible or not eligible. If that institution is eligible, then the students of that institution will get the scholarship. Lordship, my counter, my lord.
So this institution is not eligible.
Yes, my lord. That as per the inspection.
The institution of student.
Sorry, my lord. Sorry.
Yes, please.
Well, in the institution was verified. The verification report says that institution not eligible to get that scholarship. Accordingly, the students who are admitted fact, the students who are admitted through e-portal process, there is no dispute about it. But as for the verification report, the institution does not eligible to get that scholarship.
Why?
That may I bring my lord's notice to my counter, my lord?
Yes.
Lordship, my counter annexure A by 1, page 12. Lordship, got it, madam? My counter filed on 9/5/2024. May I read, madam, the Government of India's regulation guideline. It would be the responsibility to the state to empanel the eligible institutions within and outside the states where students can take admission. Students will be free to take admission in any government school, institution, college, university within and outside the domicile state. In respect of non-government schools, in college, university located within and outside domicile, each state would empanel and prepare a list of such non-government institutes and the course for which such institutes are eligible as per Group 1 to 4. States should share this list with MOTA on its portal. The state government shall ensure that empaneled non-government schools, institutes, colleges, universities located inside and outside the state possesses the desired infrastructure and has capacity to provide quality education. A mechanism will be devised for inspection of such institutions by domicile state in coordination with the respective destination state where such institute is located. This is the guideline of the same.
So this, according to you, these institutions do not.
Yes, well, that is the inspection report I have filed. You'll see that inspection report at page D by 1, page.
But their grievance is that according to your system of counseling or whatever, they were admitted in that institute.
Yes, ma'am.
All right. And they belong to scheduled tribe.
Yes, ma'am. There is no dispute, ma'am. They are admitted.
It will have to be done for them.
If that institution does not fulfill the eligibility criteria,
then you can shift them if there is such vacancy where there is some.
But
otherwise,
as per the merit, they have taken admission in that institute. So these are the private institutes.
they are private institutes.
So as per their merit, they have taken admission in those institutes.
They have taken.
Yes, ma'am. I follow my lord's.
Your public policy is that you shall encourage scheduled tribe.
Yes, ma'am. That should be.
And you will give them a scholarship also.
Ma'am.
So on your assurance, they admitted themselves in a college, which is not fulfilling the criteria. So the result is that those who were admitted.
My students are suffering.
Students.
I follow my lords.
College will suffer. College they will not allow because we know the colleges are they are the resources for the colleges.
Yes, my lord.
All right, such colleges.
In that inspection report, they have pointed 139 students were admitted.
but on the date of verification, none of the students were present.
Date was 2nd January 2024. So
Yes, ma'am.
that date also could be relevant because it is just after those vacations.
Yes. Lordship has annexed, Lordship has seen.
No, all right, the report is fine, but the date was 2nd January 2024.
Yes, ma'am. Oh, yeah, Lordship. Yes, I followed late because past January. Yes, but
Another thing, if that institution is otherwise recognized by you and they have got admitted, what is their fault?
but as per the policy of the government of India, we have to.
The institution will not get the stipend.
The student will,
get the stipend.
unless that institute falls within that policy.
Do something for
Yes.
such students
Yes, ma'am.
who are admitted and frame a policy. That at least when you win in course of verification, you don't find a particular college not fulfilling the criteria, then those students should be shifted to some other place.
But this college has 139 students. All will get, all entitled to get scholarship.
All are entitled to get scholarships.
130, only SC.
Oh, SC
Only
is less.
SC.
Sorry.
Total students 139.
SC how many?
In that.
All right. Have you pleaded the college's party?
No, ma'am.
Huh?
The college has not implemented the party.
Implead the college. Implead the college party. And counsel for the petitioner is permitted to implead. Name of the college, right?
Brahmani ITI.
Brahmani Private ITI. Is that the name?
Balughat Raulkala.
Private ITI.
And party, opposite party number so and so in course of the day. So and so, the institute for now as opposite party number. Seems to notice so the newly assessed opposite party. 1 week.
Balughat or Pamposh?
Balughat.
Balughat Panposh?
No,
Give the proper address. If you don't give, notice can't go.
No, this address notice will be served manner.
Yes. So, there are 2 writ petitions.
6.
6 writ petitions.
So 6 students. All, he's saying different institutions.
Different institutions.
Other institutions, man, they are, my lord.
So in none you have impleted the institution.
No, my lord. I will institute all the other matters, the name of the institute. I will add it. Other 5 cases, my lord.
Obligation. Yeah, Balughat post one post like the post one post. Yes, now they go.
They're all different, so you take the petition and put it.
Principal, the principal.
Principal, madam.
Principal.
Principal of the concerned college, madam.
Item 44.
Obligation.
Date
10 September.
44. May I please, Your Lordship? Here is a PIL, my lord, by the villagers. The grievance of the villagers is there is no irrigation facilities to their agricultural land, as well as the railway line is crossing in between the agricultural land of the villagers, my lord. They have represented before the authorities, my lord. After receiving the grievance, my lord, the concerned Tahsildar inquired into the matter and submitted a report, which is Annexure 5, my lord, page 31.
There is no counter. You were asked to file counter. They're paying. You filed.
Yes, Your Lordship.
I have not been served, my lord. No.
When did you file e-filing? Which date? Same problem every day. They will refile. It will not be brought on record.
I
Yes.
have also not received, my lord.
We filed it on 22nd of July, Your Lordship.
Who has filed? Who has shown the affidavit?
The affidavit has been shown by
Mr. Tripathi, what about your affidavit?
by the superintending engineer, Your Lordship. By the superintending engineer, Your Lordship, of Salandi Canal Division.
OP?
He's OP number 7.
So that is counter affidavit by who?
This is by OP number 7, Your Lordship.
No, no. Only heading must be written on whom? Only OP7?
OP7, Your Lordship. And on opposite party number 4.
Exactly. That's what I'm asking. Counter affidavit of whose? Who's the counter affidavit? See the heading of the counter affidavit. The first page of the counter affidavit.
Yes, Your Lordship. It is counter 4 and 7, Your Lordship.
Filed on 22nd.
22nd.
Four and 7. So collector and executive engineer have filed the counter affidavit.
Superintending engineer, Your Lordship.
He's not OP7.
He's been authorized, Your Lordship.
But the only grievance of the petitioner says
Yes.
that they don't have any irrigation facility.
Yes, Your Lordship, there has been, in my counter affidavit, Your Lordship, we given a report also of the superintendent engineer, the executive engineer, the Tahsildar, they all had a joint inquiry, Your Lordship. It is a fact that the railway line of the opposite party, Port Dhamra Port, Your Lordship, that is blocking the canal. And there in that inspection also, they had seen that 3 hume pipes have been laid, which are again above the land level. So water is not passing and it's blocking there. It is not, there is no free flow of water of irrigation, water, Your Lordship, on the agriculture from one side to the other.
So what have you done?
And we have reported them. We have told them to build culverts, Your Lordship, 3 culverts. They have to build, Your Lordship. That has also been intimated to the port authorities, Your Lordship. And reminder has also been given, Your Lordship. C/7 and D/7, my annexures, Your Lordship. But they have not done.
Lordship, we haven't paid.
The ground fact is that there is logging, water logging, and there is no free flow of water.
Your counter is not with us. When did you file the counter?
Also, on the last occasion, Lordship, 9th of July, the counter was served to both the parties and the counter was filed in the registry, my lord.
Just check. July, if they don't bring it on record, this is too much. I think we have to ask the dealing assistant. Check.
It is stated by counsel representing
Opposite party number 9, my lord.
opposite party number 9 that counter affidavit has been filed in this case online
No, Lordship, through physical mode, my lord.
For the port.
through physical mode on 9/7/2024.
Lordship, it was filed subsequently. The copy was served to both.
Okay, tell us the date on which it was filed. Tell us the date because that has to be indicated in the order.
Lordship, I'm not sure. I need to check with my.
They may not have filed also then.
Lordship, it has already been filed, my lord.
Then you'll have a receipt.
Lordship, I will get it, my lord. Otherwise, Lordship, we have already served the copy, both the parties. There is no point of not filing with the court, my lord.
No, there's no
Sorry.
point you might have forgotten. It may be your mistake.
Lordship, I will check, but it has.
Yes, you will check. Now you are saying you will check. You will take up the matter tomorrow.
Yes,
Because of the importance of the matter.
Definitely, my lord.
Have you addressed their issues?
Yes, my lord.
The issues raised by the government?
Lordship, precisely the 3 grievances against the OP9, my lord. First is regarding non-cleaning of the canal. Second is the culvert. My lord, regarding the cleaning of the canal, it has also been authorized by the respective Sarpanch, my lord. That's a village, the village Mirzapur, which comes under Bhattapada Gram Panchayat. The Sarpanch himself has sanctioned this and approved this letter. The canals has already been cleaned, and the culvert that particularly they were talking about, that has already been lowered, my lord. The culvert which is obstructing the canal flow of water, that has been lowered, my lord. I have mentioned in my counter affidavit.
It is actually not a culvert, your lordship. They have put hume pipes there.
No, there is difference between culvert and putting only hume pipe.
So that was the allegations in the Tehsildar report, my lord.
Not passing.
So if it's regarding human pipe, lordship, I would take instruction, my lord. As the Tehsildar report mentioned about the culvert, my lord, I specifically replied to that.
Who head your department? Who deals with this case? Deals with the issue of getting culvert installed or something? Who is the officer?
Lordship, the Dhamra Port Dhamra Port Company Limited, who maintains the railway track, my lord.
We are adjourning the matter tomorrow. We will direct officials to be personally present to explain personally to this court how this issue can be resolved. So, but just tell us which officer is to be summoned.
Lordship, the affidavit by the General Manager Legal, my lord.
General Legal will not.
Deputy Manager Legal, my lord.
So let him come. Tomorrow let us know. The officers of the state government, they will tell us who should be the responsible officer. I will direct them, we will direct them a meeting to be held. Maybe on any date, tomorrow you let us know. And then we'll see what can be done. Whether if any order is required to be passed, we're passing such order. If they agree to do themselves, so right.
Also, in the meantime, we have not received the copy of the counter filed by the state, so that I can take instruction on the counter which has been filed by the state.
I'll serve a copy right now, your lordship.
I'll let copy of the counter affidavit that you have been filed on behalf of the state served upon learned counsel representing the opposite party number 9.
As well as the petitioner also. I have also not received that.
Let the said affidavit be served upon learned counsel for the petitioner also. Properly this matter tomorrow. Considering the serious nature of the grievance which has been raised by the petitioners in the present writ application in the nature of PIL relating to land irrigation facilities, we propose to constitute a committee of responsible officials of the state government, a railway department, and local district administration to examine the issue and suggest a resolution. And officer Dhamra Port.
Yes, madam.
Patna is the railway internal track or the railway track?
The Dhamra Port
It's
Internal.
constructed and managed by Dhamra Port Company Limited, my lord. That's for carrying forward the good.
Must have lead, no? It is not a railway track. That is, sorry, that is not a railway department.
No, my lord. That's managed by the Dhamra Port
You are
Company.
representing whom?
Dhamra Port Company Limited, my lord. Okay.
Railway department. Railway, right. Railway department.
Item 45.
45 matter relating to or questioning the legality and validity of the rule, amended rule 15(1)D and proviso giving exemption to the essential qualification, that is TT pass, to the teachers to get the placement in the seniority list, gradation list, and so also to get the promotion. That is under question, my lord. And my lord was heard also extensively, and I had filed in compliance with my lord's observation a compilation the relevant provisions, my lord.
My lord, two matters are tracked together. One is the validity of statute, which they are challenging, and a writ appeal, my lord, where we have succeeded in the writ petition, my lord. In the meantime, 68,000 teachers have got promoted, my lord.
Without qualification?
No, with qualification, my lord. You can't say that. But with qualification, my lord. My lord, the rule was amended in the year 2019. My lord, they challenged the validity of the rule in 2023, after 4 years, my lord. Well, within that 4 years, my lord, 68,000 teachers have already got promotion. And my lord, they have not made a single teacher a party, my lord. So I pray, my lord,
I have filed an
intervention application in their writ petition, my lord. So time may be given.
Why are you pointing fingers towards him?
Sorry. Extremely sorry. Extremely sorry.
If you file an intervention, who is stopping you? He has challenged.
Yes, my lord.
The virus of a rule.
Yes, ma'am.
And your submission that the rule was framed in 2019 and he is challenging in 2023, that cannot be accepted. If there is any statutory provision that can be challenged at any point of time,
yes, ma'am.
unless that has been upheld earlier by any other decision. All right, so that is permissible. Persons have been given promotion, must have been given promotion because the rule was valid.
Yes, ma'am.
Subsequently, if the rule is held to be invalid, will have consequences. We don't know, prospective, retrospective. So that we will decide.
I have filed an application for intervention. I have filed an application for intervention. That has not come today.
Today also I am filing an application for intervention. Lordship, let this matter be taken up 1 week after.
Why?
At 2 p.m.
Why?
2 p.m. Then it can be had together, my lord, because we have already submitted the writ petition and the state has preferred a writ appeal, my lord.
My lord, item number WPC 35836 of 23. My lord, it is here in this
The last
bunch of there. Today we have filed the counter. It is a little different from the other, but ultimately the virus will decide all other cases. So, my lord, I have filed, given copies to my friends, and also we have filed counter. The noting says counter not yet received. It is filed today, and we have given copies to my friend. Yes.
If I will be permitted, your lordship, there are two kinds of dispute. One dispute is with regard to promotion from level 3 to level 2 and level 1. And another dispute is with regard to qualification which is required to be promoted to level 4. So this last item is concerned, I am challenging rule 11 subclause 2 and 3, which is relevant for the promotion to the level 2 and 3. For that purpose, your lordship, they have filed a counter affidavit. I'll prepare my rejoinder.
All right. You are challenging rule 11.
11. They're challenging rule 15, your lordship.
Just a minute. 11.
2 and 3.
2 and 6.
3.
On what ground?
On the ground that prior to, this is the amendment rule I'm challenging, your lordship. In the original 1990 rules, there was no discrimination. 97 rules, there was no discrimination between a graduate teacher and a lower primary school teacher. For the first time in this amendment,
when anything is amended, that happens for the first time.
My lords.
So that is different. The previous thing was this and later became this. That is also different. you will have to demonstrate that that provision violates any provision of the Constitution, any provision of the Act or other law, or any law laid down by Supreme Court. You can also challenge that it is not within the legislative competence of the authority. There is no other ground available.
I do understand. About
If you can bring your case within the four corners of this, otherwise unnecessary exercise.
I will, Your Lordship. I will suggest that, Your Lordship. But they have filed a counter affidavit today, Your Lordship, and they have served me the copy right now.
Who are you?
That matter, my lord, that 35836 of 20. That
WA.
Yes,
WPC, Your Lordship. WPC.
WPC, my lord.
The last sub item where I've challenged the provision of Rule 11, 2 and 3.
Lingaraj Naik and state, my lord. No, my lord, this is no, first matter is we have filed in
Rule 15.
that is Rule 15, my lord, 17780 of 23. And that we are adopting. That we are adopting in other cases.
In my all the cases.
Only
Is there any
two categories, Rule
provision
15, Rule 11.
under the rule which has not been challenged?
My lord, what is happening
very-
when there is a
Mr.
amendment? So naturally, some prejudice is being projected before your lordships. What prejudice is given?
The impression which I have been gathering
Yes, my
that
lord.
it is very unsafe for any authority to frame rules.
My lord.
Want to be
It all happened because of that 9 amendment, that primary education, the Central Act, my lord. And that thereafter all has to fall in line with the Central Act.
really
Your Lordship,
Today, we have
if your
requested
May I
on
bring
behalf of the parties, list this matter on. When do you want?
2
Well,
weeks,
let it
my
come,
lord,
my
2
lord.
weeks after.
Let
my
it
lord.
No,
come
Your
on
Lordship.
Monday, my lord, because they are on the other hand,
sorry,
No, my
my lord,
lord.
taking all these steps to
Well, 1 week after, my lord,
Office
maybe 1 week after.
underqualified persons, my lord.
2 weeks.
Man.
2 weeks to be taken up at 2 p.m. Stop. In the meanwhile, the learned counsel for the parties shall be at liberty to file their pleadings and counter pleadings, if so advised, and exchange them to Stop. Considering the number of adjournments which have already been granted in some of the cases, it is observed that on the next date, when the matter is taken up, the court shall not grant any adjournment.
oblige, Your Lordship.
May I pray one thing?
The registry ensure that all the pleadings which are filed are duly scanned and placed on record.
May I pray?
Grateful.
The WPC 10430 of 2024, that is first item. Even that case, I have already filed an application for intervention. That has not come. IA number 98.
Intervention in what?
Intervention, my lord, in the meantime, my lord, after amendment in 2019, these intervener petitioners, they have already given promotion twice. By relying 19 amendment, given promotion twice from level 5B to level 4.
All right, we will
So
hear you.
that is why I filed an application intervention relying.
Have they challenged your promotion?
Either they are challenging Rule 15. If Rule 15 go,
Mr. They are not challenged your promotion.
no, my lord.
They are challenging a statutory rule.
My lord.
So we will give everyone an opportunity if someone wants to argue on the question of law. All right.
I only pray that IA may be
IA
listed.
we will see.
IA may be listed.
Better.
IA 98.
IA, don't worry. Don't worry for the intervention application in such matters. They are very liberal. Yes.
Item 46.
The last sub item be segregated, even though it's from the same rule, but it does not follow any consequence.
Let it come that way.
My lord.
Item 46.
My lord, here Rule 90 capital A of the Odisha Development Authorities Rules 2020 is under challenge. My lord. In the last occasion, my lord, opposite parties have taken time to file counter.
Again, the rule challenge.
Yes, my lord.
All right, let us start your case first. Which rule is under challenge?
Rule 90 capital A of the Odisha Development Authorities rules, planning and building regulation.
See where is the rule? Where is the rule?
Kindly see page 119, 119 annexes 7. By of an amendment, this has been brought into towards the bottom. Regularization of unauthorized subplots wherein a plot has been subdivided into subplot unauthorizedly before the date of commencement of the Odisha Development Authorities Planning and Building Standard Amendment Rules 2022 and application for regularization of.
You are challenging this.
I am challenging clause 2I there of page 120, clause 2I. The applicant shall deposit compounding fee equivalent to 15% of the benchmark value of the subplot and all other applicable. I am challenging this.
What to?
Clause 2I.
I.
2I, where they demand 15% compound.
Roman.
Roman 2.
Yes,
Ma'am.
Roman
The
2 of the
applicant shall
second provision.
deposit.
Yes, madam.
The applicant shall deposit compounding fee.
Equivalent to 15% of the benchmark value of the subplot and all other applicable fee prescribed for subdivisional layout. This 15% I am challenging. Firstly, Millard, on the ground that under section 123 of the Development Authorities Act, this rule has been framed. The statute doesn't give any such rule making power to for this, Millard. So it is in varies up to of the statute, Millard. This is 1. 2, Millard. This fee they are charging.
Let us see rule making power. Odisha Development Authority Act.
May please. State government, after consultation with the authority, may make rules to carry out all or any of the purposes of this act and prescribe forms for any proceedings for which it considers that a form should be provided. Provided that consultation with the authorities shall not be necessary on the first occasion of making of the rules under this section, but the state government shall take into consideration any suggestion which the authority may make in relation
You are
to.
challenging this compounding fee.
Yes, madam.
According to you, this is they are not competent.
They kindly see 2, the subsection 2.
Yeah.
This picks out which are the areas they can make the rule. Subsection 2 thereof. In particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters.
So what is the meaning of that?
This may not be exhaustive.
Then
yes, this is one. This is one the ground that I will demonstrate. The other is they are charging a fee, and this fee is not for giving any special benefit.
That is not a fee. That is for the purpose of compounding.
Yes,
that is compounding fee.
Yes,
compounding presupposes violation.
Exactly,
All right.
Yes.
So something you have violated, they can demolish that, they can do anything, punish you. But for compounding, they have provided this fee. 15%.
Yes, what has fallen from your lordship, exactly that is the point I have taken. Then there has to be some violation committed by me. So this making the subplot is not a violation under the act.
All right, you might not have violated, but he might have violated, your colleague.
So they are charging this 15% from me, my lord.
So that you can challenge, but not the virus. Are we clear? You can challenge the action taken against
Well,
you, but not the law.
My lord, in fact, I'm praying that this provision may not be given effect to in my case. That is what I'm challenging.
In my case, it should be given in not be given in your case. But
That
it
is what
should
I'm
be given in his case. But you are challenging the virus of the rule. You can take appropriate learned counsel for the. Don't praise this.
No, my lord, I in fact kindly see my prayer.
What?
Here I have prayed that this may not be given effect to in my case, my lord. I have prayed. for.
Mr. Counsel, whether it's are you challenging validity of the rule? And in that case, the matter will go before appropriate bench. It has come before this bench because you have challenged the validity of the rule.
Yes, my lord.
So if you are asserting this, then we are
No,
dismissing your
My lord,
interpretation.
as my lord has said that there has to be certain violation. My lord, there has to be certain violation committed by anybody for them to charge the compounding fee. My lord, the act doesn't say that making a subplot is a violation under the act. So they cannot charge compounding fee for.
You please take why are you compelling us to repeat same things? That if according to you, you have not violated, and therefore you are not liable to pay fee, compounding fee, then you can take this plea before appropriate. How can you challenge the rule?
My lord, perhaps I am not clear, my lord. That is my mistake. My lord, they are charging this compounding fee for giving building permission in case of a subplot. For making a subplot. So making a subplot, my lord, is not an offense under the act.
Then you can take this plea before appropriate court.
Why? Challenge the virus for that.
No.
The rule is not bad.
You can challenge, you can appeal, you can tell the appropriate court, appropriate forum that this is not leviable on you. There is no violation, there is no disobedience.
Then, my lord, I pray that I may be relegated to the appropriate bench where, my lord, I am challenging. My lord,
Relegated, there is
My
no
lord,
question of.
So I may be relegated to that appropriate bench, my
And
lord.
counsel appearing on behalf of the petitioner after some argument submits that he shall not test the prayer made in the writ petition questioning the virus of subrule 2 of rule 90 capital A bracketed 1 subrule 2 लिखा है ना clause कर दें clause Roman 2 of section 90 capital A of the Orissa Development Authorities Planning and Building Standard Rules 2020 as amended by notification dated 30/12/2022. Also, in such view of the matter, let the matter be placed before yes.
Item 47.
May I please, Your Lordships? Well, this is this missing child, Utkal Balastram. On the last occasion, the Director, Women and Child Development, she has filed regarding the infrastructure part, my lord. As far as one child is still missing, my lord, from Jharkhand, last occasion also we had filed an affidavit regarding the steps taken by the police. So they are trying, my lord. In that case, I'll pray for a little more time, my lord. Because the address that has been given in the Balastram register is not found. There is some anomaly regarding that. So these people have gone and tried to, people have gone to Jharkhand, police personnel have gone to Jharkhand. They have been to the different, during COVID time also, and regarding even missing report also, they are trying to find out. In that case, Your Lordship may grant some more time, find out the child, my lord. Earlier. Earlier one. 2018, 17, 18.
And what about the general condition of?
General condition, last occasion, my lord, we have filed this affidavit on 15/7/2024, my lords. 15/7/2024, my lord, this affidavit has been filed by OP number 3. The Director Women and Child Development, Orissa, my lord. But this is the second affidavit filed by her. And exhaustively, my lord, everything has been, we have annexed, Your Lordship will, if Your Lordship will peruse annexure A/3, my lord, that is the number of Utkal Balastrams and the number of inmates. Then the B/3 is some positions are lying vacant for which we are trying to recruit these people, my lord. And we have also tried to find out all the children. We are trying to give all the children, provide children with their Aadhaar cards. Some children are yet to receive it. Steps have been taken for that. And as far as vocational training is concerned, my lord, D/3 shows the number of kids who are being provided with vocational trainings in different like computer, IT, and polytechnic. And E/3 is the security provisions that we have taken place, that we've undertaken. And F/3 is the funds that have been released in the last almost 7 crores 29 lakhs 84,000 have been released in the financial year 23-24 for different infrastructural. And more specifically, Your Lordship had asked for to give 4 names of Balastrams. To that I have already submitted, my lord, for visit, my lord. If Your Lordship will take a call on that, my lord, then that can be considered. That we are there. 4. Yes. The good conditions are in Puri and Balangir.
So just for appreciation, let us come to annexure A/4 of your affidavit filed in May or something. Maybe.
A/3 minus.
A/4 database of children residing in Utkal Balasram, Nuapada.
Of the construction. Nuapada, my lord, immediate steps have been taken.
No. I'm seeing one Biju say is 6 years, 10 months, 12 days old. He is in Balasram.
Yes, my lord.
Just in order to understand, could you see that?
Yes. 6 years and 10 months.
Why is he there in Balasram?
Mostly there's some orphans or they have been abandoned by the family or they've been found abandoned in.
So how do they get education?
Their primary education is given in the Balasram. After that, they are sent to different schools wherever their admission can be taken in government roads. My lord, that is why we have also shown, my lord, that is the collector report is also there, my lord, that after the primary education is given, they are sent to different schools. and imparted education. They are given vocational training also. Out of this manner, we have also shown that two boys have already got admission, got jobs.
No, they might have got jobs. But say if there are 14 students, 14 no.
In Utkal Balastram Cuttack,
No, Pada 44.
44.
One is studying they are studying in ITI also.
Yes.
So at least. Alright, give me an example. Give me just this Ganesh Das at serial number 15. He is in class 7.
Yes, ma'am.
So which school he is studying?
That I'll take instruction.
Seek instructions.
That will take instruction.
And if possible, at least these boys and girls, boys from 1 to those up to class 7, they can be sent to good schools nearby.
Yes, that can be done. Yes, that can be done.
Check the places where they are studying and whether we can provide them better opportunities also.
Yes, that I can do.
All right. So once we take up Noapada, we can take up other
In that
Balastram
line,
also.
yes, ma'am. That we can.
And likewise.
I'll need the collector is the ex-officer chairperson.
Next week, just remind us.
Yes.
If we are not able to take up the matter, then you just remind us that this is a matter which we want to
Obviously,
take up.
I'll do.
We will take up.
I will have to find out first where at all
Then
there can be
once we
accommodated.
find out where the boy they are studying, then we will find out whether they can be provided better opportunities or not.
Obliged.
Good schools, good institutions, boardings, whatever.
Obliged, ma'am. That-